I'm just using your voice.
All rise. Circuit Court is back in session.
Thank you for being seated. Mr. Klein, who's next?
Connor Maples, followed by Nolan Menardo.
This is Mr. Maples, present and approaching. Your Honor, we do have depositions that we trying to schedule. However, the state has proposed a potential PTI to Mr. Maples. I would like to leave him on the plea or continue docket for next week so I can get that agreement from the state and go over the terms and see if that's something he wants to do.
Good. Mr. Maples, I'll see you back here a week from tomorrow at 9 o'clock, okay?
Yes, sir.
Thank you, sir.
Call this week.
Nolan Menardo. Next I have Brian Moore, followed by Christian Moore.
Your Honor, this is Brian Moore, present and approaching. Mr. Moore has requested that I take depositions in this case. He is on my to depose list. We would ask for a one-cycle continuance for Mr. Moore.
Okay. Mr. Moore, do you agree to the continuance?
Yes, sir.
I'll see you back here on March 13th at 9 o'clock. Thank you, sir.
Next I have Christian Moore, to be followed by Michael Moore.
Your Honor, this is Christian Moore. We did depose, I believe, the majority of the witnesses in this particular case in 22 CF 1830. This is a trafficking case with a 3-year min-man. I do want Mr. Moore to listen to these depositions so that he can make a decision on how he wants to proceed. Given that that's the situation, I would ask the court to continue this one cycle. If there is any motion that Mr. Moore wants filed, I'll get on it and get it filed before the 13th of March.
Okay. Mr. Moore, I'll see you back here on March 13th at 9. I'm putting trial next time, which would mean if it's not resolved then we'll be going to trial in March, okay?
Mm-hmm.
Thank you, sir.
Thank you. Come
I mean, it was.
Yeah, go do it. I'd rather have too much information than I know. Michael Moore, followed by Shannon Moore.
And Shannon Moore is present and approaching, Your Honor. She does currently score a presumptive DOC sentence. However, I would like to leave her on for plea or continue for next week to see if we might possibly get these two cases resolved.
Okay, so then there'll be trial next time if it's not resolved?
I haven't even taken any depositions yet. It's a situation where if the state's willing to work with some of the charges, we might plead to probation next time.
Okay. Ms. Moore, do you agree to the continuance?
Yes.
Okay. I'll see you back here on March 13th at 9. Oh, I'm sorry.
Next week.
Plea continuance.
Yes, sir.
Okay. I'm sorry, Ms. Moore.
It's okay.
I'll see you a week from tomorrow at 9 o'clock. Okay?
Yes, sir.
Thank you.
Next I have Winston Moore, Your Honor.
This is a misdemeanor plea of costs, Your Honor, and Mr. Moore has already signed it.
Can I approach?
Yes, sir. Thank you. Thank you, sir.
Devin Morales, followed by Jeremy Merkwa.
Your Honor, this is Mr. Merkwa. We have deposed the majority of the officers involved here. I would like to ask the court for most likely one last continuance. I do want to see if I can get a mitigation report from Mr. Merkwa prepared in anticipation, probably of an open plea. So that's why I'm asking for the continuance, is for that evaluation.
Okay. Mr. Merkle, 2 months ago, I stated trial next time, meaning that we'd go to trial the end of this week to the state. Do you understand what the defense is asking for? Do you agree to that?
I certainly do, Judge. We have no objection.
Okay. Mr. Merkwood, then I'll see you on, and this was continuance, correct?
Correct, Your Honor.
On March 13th at 9 o'clock. And if it's not resolved then we will be going to trial. Thank you, sir.
I'm going to call it, I think, my assistant call. Next, I have Megan Murphy, followed by Ralph Neely.
Hello, Ms. Murphy.
Hello.
Your Honor, Ms. Murphy is going to be accepting the state's offer today. She's going to be entering a no contest plea as charged. The agreed upon terms of the plea is that she'll be placed on 4 years of probation, which will automatically terminate at any point after 2 years, once all the restitution in this case has been paid. The restitution in the case is $13,654.10. And that would be payable to Suds and Cinema. She'd be assessed $610 in court costs, $150 in public defender fees. There would be a withhold of adjudication, and given the amount of restitution involved, Ms. Murphy would ask the court to consider waiving the cost of supervision so she can apply that toward restitution.
Yes, sir.
To the score sheet.
Ms. Murphy, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
Thank you, ma'am. You can put your hand down. Ms. Murphy, did you read the plea agreement?
yes,
Do you understand it?
yes,
Did you discuss it with your attorney?
I did.
Did he answer all of your questions?
Yes,
Are you satisfied with his representation?
I am.
Did you sign the plea
I
agreement?
did.
Ms. Murphy, I do accept your plea. Adjudication is withheld. You're sentenced to 4 years probation. However, your probation will automatically terminate after the 24-month period if you've paid all restitution and haven't committed any new law violations. You need to pay the $13,654.10 in restitution, the $610 in court costs, $150 public defender's fee. Ms. Murphy, how much money do you make per month?
It's hard to say because I'm a server, but probably a little over 15
Okay.
a month.
I do waive the cost of supervision.
Thank you.
Thank you, ma'am. Good luck to you.
Next, I have Ralph Neely, followed by Marie Odom. Your Honor, this is Mr. Neely. Last week, we did depose one of the loss prevention officers in 22 CF 1934, but the main loss prevention officer did not show up for his deposition. We would ask the court to continue this. I've already talked to Mr. Stevens about rescheduling that deposition because he's got a co-defendant, and I know Mr. Harper has another co-defendant. So we would ask the court for a one-cycle continuance to reschedule that deposition.
Okay. Mr. Neely, I'll see you back here on March 13th at 9 o'clock, okay?
Sir.
Thank you, sir.
Marie Odom. Your Honor, can we leave Ms. Odom's case on for plea or continue next week? I had a meeting with her last week. I'm kind of surprised she's not here.
Any objection from the state?
No objection, Your Honor.
Okay. Plea continue, yes, sir.
Thank you. Gavin Olson. Followed by Crystal Owen. Your Honor, if we could leave Mr. Olson on for plea or continue, we've talked with the state about potential dismissal here, and I know Mr. Gomez needs a chance to look at the paperwork that Mr. Olson's going to be bringing me, but I don't want to just kick this 2 months down the road if there's a potential resolution. So I would ask the court for plea or continue on the 17th.
Mr. Olson, I'll see you next Tuesday at 9 o'clock. Okay? Thank you, sir.
Thank you, Judge.
Crystal Owen. I'll pass Ms. Owen.
Natalie Pearson, followed by Christian Perry.
Your Honor, this is Ms. Pearson. I would ask for a one-cycle continuance. It does not look like these two older cases have ever really been resolved. I know that she has been in a program for quite some time at this point. So I would ask the court for a one-cycle continuance. I already talked to her in the hall, and we're going to have a meeting here in the next couple of weeks.
Okay, good. Ms. Pearson, do you agree to the continuance?
Yes, sir.
Do you understand what Mr. Kleins is going to do on your cases to move them forward?
Yes.
I'll see you back here on March 13th at 9 o'clock. Please stay in touch with Mr. Kleins.
Thank you.
Thank you.
Next, I have Christian Perry, followed by Thomas Clute.
This is Mr. Perry, Your Honor. I would like to leave Mr. Perry on for plea or continue. We did depose the alleged victim in this case last week. Mr. Perry hasn't had a chance to listen to that. I probably expect a resolution next week, but I'd like to leave it on plea or continue.
Okay. Mr. Perry, I'll see you a week from tomorrow at 9. Thank you, sir.
Next, I have Thomas Clute, followed by Candace Price.
Your Honor, this is Thomas Clute from 22 CF 1100. I had a meeting with him last Thursday. He has just handed me some witness contact information for potentially 4 or 5 witnesses. I do need to talk to these individuals. I would like to list them in anticipation of expected trial. But I would ask the court for a one-cycle continuance so I can get those witnesses listed.
Okay, we talked about trial next time 2 months ago.
And this is a situation where Mr. Plouffe has unfortunately not been able to get this contact information to me until now. I'll leave it up to the court how to proceed.
Okay, to the state. Do you want to go to trial this cycle?
Your Honor, we have no objection to continuance as long as it's the last one.
Okay. Mr. Plouffe, if it was solely up to me, I'd say we're going to trial this month. But with the state not objecting, I will grant the continuance. And I'll see you back here on March 13th, but that'll be the last continuance. Thank you, sir.
Yeah.
Candace Price.
Your Honor, we had filed a waiver for Carl Perquette. He and his wife just tested positive for COVID. I would like to leave him on for next Tuesday. If he's symptom free, I'd like to see if we can get a resolution.
Yes, sir. So do you want a plea trial or plea continue?
Plea continue.
Okay, plea continue on Perquette.
And then the last one that I know was here earlier, Larry Pursley. Mr. Pursley is present and approaching. Your Honor, I would like to leave Mr. Pursley on for plea or continue next week.
Mr. Pursley, I'll see you next week on Tuesday at 9 o'clock, okay?
Thank you.
Thank you, sir.
I know I have a number of, you're good. I know I have a number of no-shows, but I'll turn it over to Mr. McKinney. So,
Good. Mr. McKinney?
Judge, can we go back on Larry Pursley?
Pursley?
Yes, sir. So I just need clarification. The last minute sheet says that the answer did not guilty plea, but then I also show a docket entry saying that the state announced a no cost report. Can you verify this for me, please?
Could you give me the quick number?
22 CF 2792.
should I err on the side of no process?
Yeah.
I still have that as an open case for us with no cross being filed.
Thank you. Yes, sir, Mr. McKinney?
Judge, I have Taylor Frazier before the court. Mr. Frazier is here in 22 CF 1401.
And Judge, can you tell me where that case went? Is it on for next week or is it on the second?
That one was continued, correct?
It's the next Tuesday.
So plea continued. Thank you.
Judge, Mr. Frazier is before the court in 22 CF 1401. This is the case in which the state is sent the narcotics back to the lab for a third time. This is a May arrest from last year. My understanding is that lab result for the third try around hasn't come back yet. So that puts us in a bit of a position that we really can't go forward if we don't know what that third lab report's going to say. I guess I would ask for a continuance and ask the court to charge it to the state.
To the state?
I have no objection with the continuance being charged to the state. I did reach out to MC Lee on multiple cases, because as you've heard already a couple times today, MC Lee informed us that they are extremely behind. They could not give us a number of months or days that they're behind, but they are extremely behind. We have been trying to spur them along, but I think they've had some turnover. I know our liaison hasn't been the most communicative with us as he has been in the past, so we're really trying to work on it, but that's unfortunately where we're at. If we could have one more continuance, the state doesn't have any objection to it being charged to the state, but we would like to give them every opportunity to finish the lab tests on the breast pills, and then we'll get it back.
Okay, thank you. Mr. Frazier, we're taught in judge school to be passive in substance and active in procedure. And so I try not to overstep that line. So based upon what I've heard, I do grant the motion for continuance, and I charge that against the state. So I'll see you back here on March 13th at 9 o'clock.
All right, thank you.
Thank you, sir.
Here you go. It's yours. Thank you, Mr. Frazier. There you go. Here's right here, so I'll try it. Jericho Hilliard. Mr. Hilliard is before the court in 20 CF 1657. This is a 20 CF case number because this is a return of the docket from the PTI. This is the first time we've been in court together. I believe that this is monetary, so I'm asking for a continuance until March 13th. And if we're able to get some of these amounts paid, we might be in a better position with the state when we come back.
Any objection?
We have no objection, Your Honor. We would just say, we understand it's financial and everybody has their own financial situations. If he cannot pay it in totality, we need to see at least some significant payment on that amount.
Okay. Mr. Hilliard, I'll see you back here on March 13th at 9 o'clock. Dallas lost yesterday, didn't you?
I know it. Not cool.
Yes, sir.
Oh, it's very cool.
Veronica Jones. Veronica Jones is approaching in 21 CF 2370. Judge, this is a 21 case with the 21 arrest date. I was reappointed in August. I still don't have discovery in this case. And I have spoken with Mr. Gomez, who's indicated he's going to try to get that to me as quickly as possible. I have not filed a motion to compel at this point. However, I would certainly like to get hands on it if we can leave this on docket day. If I don't receive the discovery by docket day, then I will be doing more jumping up and down.
Okay. Ms. Jones, the court's here to help. So if a motion's filed, that was where I talked about being passive in substance. Traditionally, the court doesn't take much action on its own. It waits for somebody to ask the court to act. So I'll see you back here a week from tomorrow. I did note from 2 months ago that the restitution amount was something that was being sought, right?
And that will be part of the discovery, Judge. And we had the discussion on the record that we were seeking the discovery, and really out of the discovery, what we're seeking is a restitution number more than anything else. That's something that we still need to nail down. We still need to receive the discovery to see if we can resolve this matter.
Again, Ms. Jones, I will act on whatever motion comes before the court. I'll see you back here a week from tomorrow, okay? Yes, ma'am, at 9.
Yes.
Okay, thank you.
Zaira Jones is on Zoom.
Hello, Ms. Jones.
Hey.
Ms. Jones is currently in the Humble House, which is an inpatient drug treatment program, and she has an expected completion date of April. And speaking with the state, Ms. Jones, the state has indicated that they would be in agreement with reinstatement of the PTI terms. That sounds easier than it actually is, though. I've got an email out to Ms. Barres to see if we can agree just to reinstate the PTI, or if a new PTI paperwork needs to be presented to the probation office. I know I spoke with probation earlier today, who indicated that it would be easier to do a new PTI. Regardless, Ms. Jones is in the inpatient treatment program. I do have access to send her stuff via the mail. I would request that we ask for a continuance. And it sounds like this is going to drop off the docket one way or the other once we reach an agreement on the procedure on how we get to where we're trying to go and reinstating the terms of the PTI.
Okay. So on one cycle continuance?
Yes, sir.
Ms. Jones, do you agree to the continuance?
Yes, Your Honor.
Okay. Ms. Jones, I'll see you back here on March 13th at 9 o'clock unless your case is resolved before that, okay?
Okay, thank you.
And Ms. Jones, I really wish you the best in your program there, and thank you for your hard work.
Thank you, Your
Thank you,
Honor.
ma'am.
Bye.
Goodbye.
Good day.
Christopher Rivetti, followed by Miranda Rice. Mr. Rivetti is approaching in 22 CF 2770. We have depositions scheduled for this Friday, so I'm going to ask that this come back on docket day. So we should be in a better position to know how the depositions went when we come back on docket.
Okay. Do you agree to the continuance?
Yes, sir.
I'll see you, well, it's not a continuance. I'll see you back here a week from tomorrow at 9 o'clock, okay?
Okay.
Thank you, sir.
Miranda Rice. You got a call from Miranda Rice earlier today in the hallway. I do represent her in 22 CF 2125.
What does the state seek? Capias will be issued for Ms. Rice, and the first appearance judge will determine the bond.
Michael Ross. Mr. Ross is approaching in 22 CF 2558. Judge, Mr. Ross is going through the process of being evaluated for Keaton for inpatient drug treatment to see if that might be an option within this case. I'm going to request a continuance, as I do not anticipate having an answer by docket day. They have been rather slow in getting us answers for placement.
Yes, sir. Mr. Ross, I'll see you back here on March 13th at 9 o'clock. If you want to avoid 300 people and you want to enter a plea before then let Mr. McKinney know, and we'll talk about that plea at that point, okay?
Thank you, sir. Have a good day.
Thank you, sir. You too.
Demetrius Rudolph, followed by Joshua Salerno. Rudolph. Judge, we're going to be entering a plea with Mr. Rudolph. I don't see him in the courtroom. He was here all morning. May I pass that to the
Sir. Yes, sir.
Judge, this is Mr. Salerno, also on the docket is Salernos, 22 CF 772. Judge, I'd like to leave this on docket day, plea or continue, to see if we can get any ground made towards getting an FDLE lab report. It is a probation offer for Mr. Salerno, and he wants to wait until we see the results from the lab before we enter any type of plea agreement. So I'd like to come back on the 17th at 9 a.m.
Okay. Mr. Salerno, I'll see you back here a week from tomorrow at 9 o'clock. Thank you, sir.
Dina Robeson, followed by Cecil Rowell. Ms. Robeson is before the court in 22 CF 1341. This is another case where we're awaiting FDLE. We've already set depositions in the matter, which are scheduled for the 14th of February. So we're going to request a continuance so that we can complete the depositions and hopefully get the lab results.
Okay. Ms. Robinson, do you agree to the continuance?
Yes.
I'll see you back here on March 13th at 9 o'clock, okay? Thank you, ma'am.
Make an appointment to come in and see me. Judge, this is Mr. Cecil Rowell. Mr. Rowell is before the court in 22 CF 585. Mr. Rowell has been evaluated by Dr. Zeman and been found incompetent to proceed. And that brings us to a position where I'm going to ask the court's opinion on where we should set this. I believe that it should be set for a competency hearing because Dr. Zeman's recommendation is for a conditional release. Mr. Arello is already under care with the Agency for Persons with Disabilities, and Mr. Sanchez has provided me an order to provide to the court that cuts out Mr. Barnes, which normally the court would involve Mr. Barnes in a conditional release plan. So I've reached out to Mr. Barnes to see how that process would work, to make sure the court would be informed from Mr. Barnes, like he normally would in a case like this, to see if we need to have both parties in the courtroom making sure the language is correct rather than each side pointing out the other. So I'd like him to be taken off of a pretrial date if we could set this on a miscellaneous date in the first in February, whatever Ms. Brickman is fine with, because it's primarily procedural, and I believe that Mr. Barnes would be in a position to hopefully have us a conditional release plan by the time that we see the court again.
Okay. Mr. Roll, I'll see you back here on February 16th. We want it in the morning or the afternoon?
I don't believe it would be a contested hearing, so it would be mostly procedural. If we could set that in the morning, but I'll defer to Ms. Brickman.
I believe that the morning would be fine. However, if we put it on the 13th, 20th, or 23rd, I was planning to be out on the 16th.
And the 13th, I've got it stricken on mine. I'm not sure why.
I think you have it.
Okay. Yeah, I don't think we have February 13th.
What about the 20th
we
or
can
the
do
23rd, miscellaneous dates?
February 20th at 9 o'clock. So February 20th at 9 o'clock, and then just for Madam Clerk, you can run it on the March 13th. Okay.
And that was the 20th?
Correct. February 20th at 9. I'll see Mr. Rowell. Good seeing you, sir.
You too.
Thank you.
Zachariah Rutherford. Mr. Rutherford is approaching in 22 CF 371. Mr. Rutherford's brothers, which are also on the docket, have already previously been continued until the next date. I'd ask to track along because we have been following along with the depositions completed by the other counsel. So we're going to be doing another round of depositions, I'm sure, but I'm waiting for that to be scheduled, and they're going to tag along on that.
Okay.
So I request a continuance to join the other two cases on the 13th of March.
Mr. Rutherford, I'll see you back here on March 13th at 9 o'clock. Stay in touch with Mr. McKinney. Okay?
Yes, sir.
Thank you, sir.
You don't have to get me up there right before they go.
No, I don't remember.
But go ahead and schedule a time to come in and talk to me too. I have that there. Wilmer Sherling.
Hello, Mr. Sherman.
Hello. Mr. Sherling is before the court in 22 CF 1721. And Judge, this is a situation where the state has made an offer for probation. We are still waiting for a lab result in this case as well. So I'd like to come back on docket day just to see where we're at as far as kind of a status type setting to see if we have everything we need to fully advise Mr. Sherling.
Okay. If you don't have an FDLE report, do you want to waive Mr. Sherling's appearance?
Yes, Judge, I'd like to. I don't want to move it all the way to March if we get it tomorrow, but if we don't have a lab result, then I would ask the court to allow waiver of his appearance.
Okay. So, Mr. Sherling, that means that I'll see you a week from tomorrow at 9 o'clock, unless Mr. McKinney calls you and says or communicates with you and says you don't have to be here then, and then he'll give you the next date you need to be here. Okay.
Is that phone number still the best for you? Yep. Okay. So I'll touch base with you at the end of the week, see if you have any report next Tuesday or not. Okay.
Thank you, sir.
Nikki Smith is on Zoom.
Hello, Ms. Smith. Ms. Ms. Smith, if you'll take your microphone off mute, I'll see if I can help you. There you go. Good.
Judge,
Yes, sir.
Ms. Smith has two case numbers, 20 CF 2090 and 21 CF 3255. Ms. Smith is currently in I believe, a quarantine at this point for
Yes,
COVID.
sir.
So I'm going to request that this come back on docket day and allow Ms. Smith to appear via Zoom at that point. On the 2090 case, we have to verify with the victim the restitution amount, which our intention is to read into the record for a pay and dismiss situation. And then in the additional case, the 21 CF 3255 is a large amount of paperwork that we still need to set depositions on. So I'd like to come back on docket day, plea, or continue with the intention of getting at least the 2090 case wrapped up to be able to read the restitution into the record.
And Ms. Smith can attend via Zoom?
I would ask the court for her to be able to do that.
Ms. Smith, I will see you via Zoom a week from today at 9 o'clock, okay?
Yes, sir.
Thank you, Ms. Smith.
All right, thank you.
Philip Smith?
Yes.
Ms. Smith, I believe that you're fine to sign off.
Yes.
Judge, this is Philip Smith. Mr. Smith is here in 22 CF 2365. We were able to get deposition scheduled for this Friday, so I'd like to come back on docket day to see if that puts us in a better position.
Okay? Mr. Smith, I'll see you a week from tomorrow at 9 o'clock. Okay? Thank you.
Agnes Stallworth, followed by Richard Stevens. Ms. Stallworth is approaching.
Hello, Ms. Stallworth.
How you doing?
Good, how are you?
She's here in 22 CF 2472. Judge, at this point, I do need to meet and talk with my client. The state has tentatively wanted to reach out in plea negotiations. I've been unable to do that without being able to speak with Ms. Stallworth. I would like a continuance so that I could have Ms. Stallworth come meet with me at my office and see exactly where we stand with the case.
Mr. McKinney, do you have room on your calendar to meet with Ms. Stallworth before next Tuesday?
I can certainly try, but that would be tomorrow.
Okay.
Okay.
Yeah.
So, Ms. Stallworth, I'll see you back here a week from tomorrow at 9 o'clock. Make sure that you see Mr. McKinney tomorrow,
Okay.
because I'm ordering you to see him before I see you next week, okay?
Okay. Thank you.
Yes, ma'am, thank
Before
you.
she steps away, let me look at my calendar to set her a time before she steps away.
Sure.
Can you be in my office at 9:30? Does that work? 12:30?
What you got an appointment at? I have a doctor's appointment. If you need to take it around.
You want to come talk to me 12:30?
Yeah.
Okay.
That's okay.
Sure, I'll make it happen.
So what time tomorrow, Mr. McKinney?
Judge, she's going to come meet with me at 12:30 tomorrow at my office in Shalimar.
Okay, thank you.
Would 9:30 be better? Yes. That's what I was trying to do. Okay.
9.
Not if you're at your other appointment. We're going to write all over this thing. Okay, that's okay. 9:30 tomorrow at my office. Okay.
All right.
Okay.
Thank you. All right.
All right.
Thank you, Ms. Stallworth.
All right. Thank you.
Richard Stevens, followed by Prashant Toomer. Judge, Mr. Stevens is here in 22 CF 272. We have completed the lion's share of the depositions in his case with CAC. My notes indicate that I've reached out to an expert to review the digital evidence, which would be Mr. John Sawicki out of Tallahassee. And in all candor to the court, I have not heard from Mr. Sawicki in a much longer time than I would normally. So I'm a little bit concerned about where we're at with that. I don't have any answers from him relating to Mr. Stevens or several other cases in which I've reached out to him. That's the last piece of the puzzle before we would be able to say we're ready for trial for Mr. Stevens and a number of other CAC cases. So I'll defer to the court as to scheduling, as we are getting down the path on this one. I would be requesting a continuance on my end, because hearing from next would be the last thing we need to do.
To the state, what do you wish to do?
The state has no objection to that. I know I'm very familiar with Mr. Sawicki, so this is not the first time I've heard this morning, so I will try and figure out what's going on for a number of these cases. So
Okay.
we would have no objection at this point.
Mr. Stevens, do you agree to the continuance?
Yes.
I'll see you back here on March 13th at 9 o'clock. Stay in touch with Mr. McKinney.
Very good, thank you.
Thank you.
And Judge, if we do reach any type of agreement, then obviously we can ask the court for additional time to get back in front of your honor.
Absolutely, yes, sir.
Schedule a couple of regardless. Mr. Toomer, followed by Christian Viljon. Mr. Toomer is here. He's here in 22 CF 2110. This is a trafficking case that we do need to set depositions. It has not made it on the schedule yet for the depositions. So it's likely going to be in a position, unless we're able to make substantial headway before March, that I don't know if we'll be ready for trial at that point. But I'm requesting a continuance until then to start working on it.
Okay. Mr. Toomer, I'll see you back here on March 13th at 9 o'clock, okay? Thank you, sir.
There you go. This is Christian Viljon. Judge, he's here in 22 CF 1382. We've done one round of depositions. We were seeking more information from the state relating to a number of additional juvenile witnesses. I did see that I received that information today while we're in court. So we're going to be scheduling another round of depositions that will likely all be videotaped. I'm going to request a full continuance to do that, given the logistics that it's likely going to take.
Okay. Do you agree to the continuance?
Yes, sir.
Okay. I'll see you back here on March 13th at 9 o'clock. Thank you, sir.
Okay. Joel Walls, followed by Matthew Warner. Judge, Mr. Walls is approaching in 21 CF 1796. Last discussion we had with the court was about the filing of a motion to suppress. In doing the preparation for that, and I found that we needed additional records from the state relating to the officer's speedometer. So I've requested that from Ms. Davis prior to us filing and scheduling the motion, because I know that that's going to be an issue at the motion hearing that I wanted to get out ahead of instead of learning about it in the courtroom. So I'm going to defer to the court if we leave this on docket day or to ask for a continuance. I know that upon receiving that information, we are filing a motion to suppress that will then be scheduled for a hearing. If the court wants to hold our feet to the fire and come back on docket day to see where we're at with that, I'm fine to do it that way.
Okay. Any way that you'll be ready for trial, or should I say, please continue and that Mr. Walls doesn't have to be here next week?
There's no way we're going to be ready for trial because I've drafted the motion for suppression, but I know that there's additional documentation out there related to the officer's speedometer that we need to plug in there, because I know that I'll be asking that question at a hearing.
Okay. Mr. Walls, I'm going to set your case for a week from tomorrow at 9 o'clock. You don't have to be here then. You'll need to be back here on March 13th at 9 o'clock. Okay?
Yes, sir.
You're certainly welcome to come next week if you want to.
No, I'm good.
I just wanted to see what's going on with the additional information regarding the motion. Okay?
Okay.
Thank you, sir.
Appreciate it.
That's when you need to be back, but we're going to be addressing it next week with the judge. Yep. Yeah. Yes, sir. Matthew Warner. Matthew Warner is here in 22 CF 1917.
Good, how are you?
Madam Clerk, Matthew Warner also on a felony plea date has 22 CF 3120, in which case there is a 6-count information which has already been filed by the state that we would enter a plea of not guilty to. Given that that is a new case, I obviously don't have any discovery on it yet. I would be requesting a continuance and would ask for both case numbers to be placed on the same date.
Okay. Mr. Warner, I'll see you back here on March 13th at 9 o'clock for both of your cases.
Yes, sir. Thank you.
Just for Mr. Warner to be aware, I know there was an affidavit of surrender by the bondsman. If that is not served here quite soon, I'm going to be filing a motion to revoke his pretrial release for the first case, because that was a possession of a controlled substance case. The new case is a trafficking case.
Okay, thank you.
Talk to your bondsman. Given that that's not been filed to be heard with the court today, then I'll certainly keep abreast with Mr. Warner to see if we need to set any hearing dates with your honor.
Excellent, thank you.
Stephen Weaver, followed by Christopher White. Stephen Weaver. Did you have a chance to read that through?
Yeah.
So it's misdemeanor? $270 and $150, that's it. You good with that?
Yeah, I'm good.
You sure?
Yeah.
It's okay.
Have you signed someone?
Did you read it through? Do you have any questions?
Hey,
Good, Mr. Weaver, how are you?
I'm working
Good.
If you don't have any questions, you need to sign it at the top. Judge, we've reached an agreement in Mr. Weaver's case. Mr. Weaver was able to show a valid license to the state. This is a driving case based on 23. In exchange for that, the states are in a position to offer a reduction down to a second-degree misdemeanor, no valid driver's license. The agreement would be for an adjudication of guilt on the misdemeanor, $270 in court cost. 300 even?
Yes.
Okay. 300 even, and a $150 cost of defense. We would ask for time to pay that amount. He's currently on a payment plan with the clerk's office.
Okay, thank you. Mr. Weaver, if you'll raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you.
Always.
You can put your hand down. Mr. Weaver, did you read the plea agreement?
Yeah.
Do you understand it?
Yes, I do.
Did you sign it?
Yes, I did.
Mr. Weaver, I do accept your plea. You're adjudicated guilty of the misdemeanor. You'll need to pay the court cost of $300, public defender's fee of $150. How long will it take you to pay those amounts?
Well, I'm already on there for $1,200 on a monthly thing downstairs. You can add it on the file, however you want to do it.
Do you, how much money do you make per month?
$2,000.
Okay. Then if you fail to pay this additional $450 within...
I'm gonna pay it.
Okay.
Give me 90 days.
How about if I was going to give you longer than that. How about if I say 9 months, okay?
Well, that will be fine.
Okay. If you fail to pay it within 9 months from today, then it will go to a civil judgment.
Yeah.
It'll go to civil, not criminal, okay?
Yeah,
Thank you, sir.
thanks. I signed the 275, by the way. Just kidding, just for you. I'm just joking, I'm good.
You good? Sure?
Yeah.
Okay.
Yes, sir. Who's next?
Judge Scott White. Scott White. Okay. Christopher White. Judge, this is Christopher White before the court in 22 CF 2683. Judge, we were in a position where we got some additional witnesses for EMS folks who were at the scene at the end of December. Those witnesses are local. I'd like to depose them first as to whether or not this is a leaving the scene with injuries or not, as the victims are in Atlanta and Columbus, Georgia. So I'd like to see if we can do the EMS depositions first before seeing if we have to make arrangements for travel or some sort of Zoom depositions related to the out-of-state witnesses. It's a long way to ask for a continuance, but I wanted the court to know where we're at as far as scheduling the depositions.
I appreciate that. Mr. White, I'll see you back here on March 13th at 9 o'clock.
Yes, sir.
Thank you, sir.
William Williams, followed by Philip Wilson.
Well, Mr. Williams.
Judge, Mr. Williams is before the court in 22 CF 2478. This is a relatively new CAC case. We have not set depositions yet with CAC. We intend to. I would ask for a continuance so that we can start scheduling those dates.
Okay. Mr. Williams, do you understand what Mr. McKinney's doing on your cases?
Yes, sir.
Do you agree to the continuance?
Yes, sir, I do.
I'll see you back here on March 13th at 9 o'clock.
Yes, sir. Thank you.
Thank you, sir.
Have a nice day.
Philip Wilson. And that's followed by Karen Wright. Mr. Wilson is standing with me in 22 CF 166. Judge, in his case, we would like to leave this set on the trial docket. We have a meeting tomorrow to determine whether or not we're going to be filing any pretrial motions relating to suppression of statements. There were some different versions of events given by different officers in this case, and I've got to discuss that with Mr. Wilson to determine how we should best proceed here, and I wanted him in on the loop on that. So I'll defer whether or not we want to announce this as ready for trial with sending out subpoenas, or if we want to leave this in a position where we come back to docket day to then see where we stand.
To the state, I'm leaning toward, we said trial next time, last time. Also, the motion was mentioned 2 months ago.
Correct.
So I was thinking plea or trial.
That's fine, Judge, we can do that.
Okay.
That's fine, Judge.
Is there an offer to Mr. Wilson that the state intends to withdraw if Mr. Wilson doesn't accept it next week?
Yes, Judge.
Mr. Wilson, the reason why I ask that is I want you to know what your homework is. Your homework is to consider whatever the state's offering you. You decide whether it's in your best interest to accept it, taking into consideration the advice that Mr. McKinney gives you, okay?
I can put on record that Mr. Wilson scores as charged 36.4 points, not months, points.
Judge, at this point, the state would be fine with probation on Mr. Philip Wilson's case.
So, how long on probation?
3 years, Judge.
Okay. So, Mr. Wilson, think about that, talk to Mr. McKinney, and I'll see you a week from tomorrow, okay?
And Judge, we have a meeting set at 9 o'clock tomorrow at my office, so we'll discuss that then.
Excellent. Thank you, sir.
Okay. Karen Wright.
Hello,
Ms.
Ms.
Wright.
Wright.
Ms. Wright is before the court in 22 CF 1185. And we have reached a position where we were discussing with the court the ability for Ms. Wright to pay and dismiss if she were able to pay the full restitution amount. She has substantial medical problems and has been unable to work. That's led us to a position where, as an alternative resolution, the state has agreed to a 6-month deferred prosecution agreement, which I do have signed by myself, or actually my client and Ms. Davis for the state attorney's office. And this is a DPA with a plea that if the terms of the DPA are not satisfied, if the payment of the restitution is not made over the 6 months, then the plea agreement would be entered and it would be sentencing by the court at that time. So Ms. Wright has reviewed a plea and sentencing agreement that will be held in abeyance as long as the DPA is completed. That's signed by myself. Actually, I have it signed this the way that they write DPAs by my client and the state. May I approach Madam Clerk of the court? The court may want to discuss that with Ms. Wright.
Well, my question is, when you said to be held in abeyance, the plea agreement, okay.
The plea agreement will not be
Ms. Wright
given-
is basically, if she doesn't pay the restitution within 6 months from today, then it's going to be a plea straight up.
Correct.
With no agreement on the sentence, correct?
Correct.
Okay, yes, sir.
May I approach?
Please. Ms. Wright, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, ma'am. You can put your hand down.
And Judge, this would be a regular deferred prosecution agreement. It would not be a PTI through probation and parole.
Okay. So
No, if they complete the DPA.
what happens with the plea and sentencing agreement? When you say it's held in abeyance,
In the past,
it's really not. It's really, she's entering the plea agreement, but then there's just no sentence unless she doesn't fulfill the DPA, right?
we would set a control date from 6 months from today to see whether Ms. Wright has completed the terms of the DPA.
I'm just trying to figure out, is this contract valid right now or is it not? In other words, am I filing it with the clerk?
Yes.
I would say yes. I mean, the intention here is that she never gets to sentencing if she
Right.
completes the DPA.
I agree. I think we're all saying the same thing. Ms. Wright, so if you fail to pay the restitution within 6 months from today, then you're waiving your right to a trial by jury. Do you understand that?
Yes, sir.
And that you could be sentenced up to 5 years in prison.
Yes, sir, and $5,000 fine and yeah, everything that was on there.
Yes, ma'am.
Yes, sir.
Right. I have no idea what I'd sentence you to if you don't fulfill the terms of the deferred prosecution agreement. But as long as you know the maximum downside, which you do, then I think that's all that I need to tell you. Okay. So
does this mean like if I pay the money and nothing happens, it goes away?
correct.
Okay.
Right. Yes, ma'am. So we'll set it for 6 months from now, on July 10th at 9 o'clock. That's only if you don't fulfill the terms, okay?
So
Thank
if I
you.
pay it, I don't have to show up for that date?
Correct.
Okay.
You pay it, yeah, you pay it in full, that's when you call me, you let me know.
Okay.
That way I can start ringing up the prosecutor and calling back.
Okay.
All right,
Thank you, ma'am.
Have a blessed day.
Okay. Summer White. Ms. White is approaching in 22 CF 2002. This is another case that's in the same boat with FDLE. This is a probation offer that I'd like to leave this on docket day to see what the status of the FDLE lab report, to see if we can get some answer by then, so I can inform Ms. White kind of what we're looking at as far as the timetable here, as far as the lab results.
So you want plea continued?
Correct.
Do you want to waive Ms. White's presence if you don't have the FDLE report?
I would request that.
Okay. Ms. White, so I'll see you here a week from tomorrow at 9 o'clock, unless Mr. McKinney calls and tells you that you don't have to be here. So if he doesn't get the FDLE report by that time, then he'll call and say you don't have to be here, in which event I'll see you on March 13th. So stay in touch with Mr. McKinney.
And the 17th. So touch base with me at the end of the week, and I'll know where we stand.
Okay, thank you, ma'am.
Judge, I have a number of others that have waivers that aren't people in the courtroom. Does the court wish me to go through those?
No, sir, let's go ahead and, anyone else, any other defendants in the gallery or on Zoom?
I have one in the audience, Judge.
Okay, yes, ma'am, Ms. Jacob.
Mr. McNamara?
Okay, good, yes, sir, we'll come to you 1 minute on Zoom after Ms. Jacob does it, and I'll recognize you. Thank you.
Here, this is Kevin McNamara before the court. The court previously issued a capias for Mr. McNamara, and I did see him right as I was leaving. That case number is 22 CF 2789, so I'd ask that the court withdraw that capias. I was recently appointed to this case, so I just got discovery. I have spoken to Mr. Gomez about it, in that I think there's some case law issues with the facts of the case, but I don't believe he's even come out for me to look at it because I just got discovery and just provided it to him. So given that, we'll need to continue it to the March 13th docket.
Okay. I don't think that I set a capias for Mr. McNamara. I think we just passed it. I did? Okay. Capias is withdrawn, Mr. McNamara. I'll see you back here on March 13th at 9 o'clock. Make sure that you stay in touch with Ms. Jaquith. Make sure you're on time next time.
Yes, sir, I apologize.
Thank you, sir.
You have a good day.
You too. Okay, then the folks,
Your Honor, Kevin Morales.
okay?
Your Honor, this is Mr. Morales. I don't believe the court issued capias on any of mine. I just kind of skipped over. With Mr. Morales, he is going to ask the court for a one-cycle continuance. He is attempting to get his driver's license back, which hopefully would have some impact on plea results. So I would ask the court for a one-cycle continuance so he can attempt to do that.
Okay. Mr. Morales, I'll see you back here on March 13th at 9 o'clock, okay?
Thank you.
Thank you, sir. Mr. Kleins, Mr. McKinney, do you have any clients that are on Zoom?
Mr. Weathers,
Mr. Weathersby is my client. He's under iPhone. I didn't see his name on there.
Mr. Weathersby, how are you?
I'm here, I'm right.
Oh, okay. Yes, sir.
Mr. Weathersby lives in Kalamazoo, Michigan. Is that right, sir?
Yes, sir, it is.
And Judge, I'd like to see if we can come back on docket day to see if we can reach some sort of a resolution for Mr. Weathersby that doesn't involve him coming back to Florida.
Okay, so you're saying plea continue and he can appear via Zoom?
We would ask for him to be appearing via Zoom since he's in Michigan.
Okay, and this is DeCarlo's Weathersby, right? 22 CF 2360. Mr. Weathersby, that means that I'll see you back here via Zoom next week on the 17th at 9 o'clock, okay?
Yes, sir.
Thank you, sir.
Mr. Weathersby, I'll get an answer from the state and reach out to you, okay?
All right, yes, sir, thank you.
And Judge, I see Israel Mount as well.
Mr. Mount?
Originally, I represented Mr. Mount on a PTI. It was returned to the docket. I don't know if this is going to be me or Mr. Klein's that has this case now, but I'm familiar enough with it that I can speak to his case.
Okay.
Judge, Mr. Mount now lives out of state and is seeking the ability to pay off the outstanding amount, which has placed it back on the PTI, back on the docket. So I would ask for a continuance for Mr. Mount to see if we can make some sort of payment arrangements.
Okay. Mr. Mount, I'll see you. Do you want Mr. Mount to appear via Zoom or does he live locally?
He lives out of state. Mr. Mount, are you in Texas now? You're testing my memory.
St. Louis.
You where, sir?
I'm in St. Louis, sir.
I knew he was out of state. So, Judge, I'd ask for him to be able to appear via Zoom because it sounds like if we're able to make arrangements for payment, we may be able to reach an agreement without him having to come back in person.
Okay. Mr. Mount, I'll see you on March 13th at 9 o'clock via Zoom, okay? Thank you, sir.
And Madam Clerk, can you just input me on that case and I'll just make sure it's mine?
Thank you, Mr. Mount.
No problem.
Hi, I'm still here.
Good. Yes, ma'am.
Hi.
Yes, ma'am. You're a defendant?
I am.
Okay. Who represents you?
I am currently not represented. This is a matter of my PTI.
Okay. Hold on one second. Hold on. I don't want you to say something that may hurt your case, and I'm glad that you said that. Yes, ma'am, and you're Elizabeth, correct?
I am.
It's 20 CF 2196. How do you pronounce your last name?
It's Lucini.
Lucini. Ms. Lucini, do you wish for me to appoint? Well, let me first ask the state if they have an offer for you. Do you have an offer for Ms. Lucini? She's number 157, at least on the docket I printed off. She was pro se. If you'll pull that microphone toward you.
Yeah, sure. I gotta find this case in the box.
Thank you.
Your Honor, I believe this has something to do with my cost. I'm prepared to pay those in full at the conclusion of this.
Okay. I'm waiting for the state to get up to speed.
Sure.
Yes, if I'm not mistaken, there are still some outstanding costs that need to be paid. I think there's court costs in the amount of $615 that were still outstanding.
So if Ms. Lucini pays those, we'll figure out a time period, then the state's going to dismiss the case?
Yes, Your Honor. We would still honor the DPA as long as she completes all of the original requirements.
How long do you want to give Ms. Lucini to pay?
I mean, Ms. Lucini, how long would it take you to pay?
I'm actually prepared to pay it today. I've been trying to pay it for the last couple of weeks, but there was a hold on it that was contingent upon today's proceedings.
Okay, no, I'm familiar with this now. If we want to go ahead, can we set it, we can do it on the 17th?
Yes, sir.
And then that way, I think the holdup is once our office notified the clerk that it needed to be put back on the docket. There was technically no court cost to be paid, and so whenever she would call in, there would be nothing they could technically accept because there was no amount.
Okay, so for the record, it's how much?
$615 is per the agreement that was entered into on the on February
So you
18th.
put on the minutes that Ms. Lucini owes.
So if she was trying to pay online, if the case comes back in that status, she will not be able to pay online, but she can make a phone call.
Okay, did you hear that, Ms. Lucini?
It was a little foggy. Let me
So
read it again.
if you can't pay online, it'll probably take a little bit for this court date to process and then to be able to pay online. If you can't pay online, you should be able to call into the clerk's office and pay over the phone.
I had that issue prior to today, and so I called the clerk's office and they were unable to do it either. So if there's a time period that we're looking at for this to be able to clear, what would that be?
Well, I'm just trying to make sure that I don't put you under the gun when the clerk isn't ready to accept the payment. So there's nothing that I can put on the minutes. Hold on one second. There's nothing that I can put on the minutes that then would clear the way for Ms. Lucini to pay that amount.
Well, the money has been in the case since the DPA was entered.
Okay.
Did she try to make a phone call and they didn't take it? Because we take payments over the phone.
From what I understand happened, I think that this was a situation where it wasn't paid, and then we brought it back on the docket, and she tried to pay, and then when that happened,
Correct.
the clerk's office was, hey, we can't take this because there's no set amount. Now that this is back on the docket, I don't know.
Okay.
So Madam Clerk, you said the 615 is on the docket?
Yes, sir.
Okay. So Ms. Lucini should be able to call and give a credit card information?
Yes, sir.
Okay. Ms. Lucini, can you do that?
Oh, absolutely. I can do that as soon as we're done here.
Okay. Then I'm going to schedule you for a hearing on next Tuesday, a week from tomorrow, at 9 o'clock. So if you haven't paid that and the state hasn't dismissed the case, then I'll see you on the 17th at 9, okay?
Okay, and assuming, which I plan to pay it
Yes, ma'am.
immediately, then I won't need to log on to here to meet with y'all on the 17th if it's paid?
As long as the state dismisses the case, then yes, ma'am.
And how will I know if it's dismissed?
You'll dismiss it, and then a copy will go to the...
Yes, Your Honor.
The state will dismiss it with the clerk, and the clerk will send you a copy. Does the clerk have your email address?
I'm not sure if they do. Can I give that to
No,
Paul?
ma'am. Do you want it now, or do you want to call in and get it?
You can take it now.
Okay, if you'll give your email address now, Madam Clerk.
Okay, just to clarify, I should be able to pay it today?
Yes, ma'am.
Wonderful. Thank you so much.
Thank you, ma'am.
Have a great day.
You too. Okay. Speaking of pro se's, Marcus Lovett. I don't see. Yes, sir. Yes, sir. What's your name?
Nicholas Schneider?
Nicholas Schneider. Mr. Schneider? Mr. McKinney standing up?
Mr. Snyder had informed my office that he was COVID positive and sent me the results for that. So I was going to bring him up at the end. I told him he didn't need to appear given that. But since he's on Zoom, I would ask for Mr. Snyder to come back on docket day, plea, or continue. Mr. Snyder's case number is 22 CF 1860.
And Mr. Schneider can appear via Zoom.
Mr. Snyder, how do I ask this without putting all the information on the record? Are you believe that you're going to be symptom-free by the time we get around to the 17th? Judge, can we schedule him for docket day, and if he's still showing symptoms, he can communicate with me, and then I can inform the court. But Mr. Snyder, I'd like to come back on the 17th to see if we can resolve your case.
Okay, so Mr. Snyder, you'll need to be here live a week from tomorrow at 9 o'clock, unless you talk to Mr. McKinney and he says that you don't have to be here live, okay?
Yes, sir.
Okay.
Mr. Snyder, I'll reach out and talk to you on the phone once I get back to the office, probably tomorrow.
Okay, thank you so much, sir.
Yes, sir.
Thank you. Okay, then I had some pro ses. Marcus Lovett. I don't see Mr. Lovett. We'll come back to that. Tyler McKinney. I don't see Mr. McKinney. John Douglas Midget.
Yes, sir.
Mr. Midget. It's case number 22 CF 2517. Come on up, Mr. Midget. Does the state have an offer for Mr. Midget?
Hold on, I'm trying to. Your Honor, I think the current offer that we had outstanding was an 18-month PTI. That part of those that agreement would include a restitution in the amount of $2,487.94, community service work of 24 hours, no trespassing at Lowe's, and anti-theft class. That would be something though that in order for us to enter into that agreement, the PTI would have to go through Mrs. Veras for that. To be able to coordinate that. If that's something that he's interested in, I would need to get his email address and some contact information, and I have to get that ball rolling with the probation officer.
And the upside to Mr. Midget is if he does those things, then his case is dismissed, correct?
That's correct, Your Honor.
Mr. Midget, is that what you wish to do?
Yeah, I just had one question about the restitution.
Okay.
What is the purpose of the restitution? Like,
It's to pay back the alleged victim what they say they lost.
okay, and then that was another question. I believe everything was returned to the so
Okay.
that's the only thing. But I'd definitely love to do that.
Okay.
I just wanted to bring that up.
So to the state, you want his email address, and you can
Yes.
double check with the alleged victim?
Yes, I definitely.
Figure out an amount? Good.
Definitely. Thank you, Your Honor.
Yes, sir. So, Mr. Midget, I'll see you back here before you leave. Make sure you give him your email address.
Can I have him just run over real quick?
Sure.
So I can get it?
But, Mr. Midget, I'll see you back here on March 13th at 9 o'clock.
Yes, sir.
If you haven't entered the pretrial intervention program. So if you've entered that and you've successfully completed everything, then your case will fall off the docket.
Yes, Your Honor. Thank you very much. And then,
Yeah, 325 over here.
Richard Potter is next. Hello, Mr. Potter. Case number 22 CF 2694. Does the state have an offer for Mr. Potter?
Your Honor, if I'm not mistaken, this was more, I think we had given him some time to see if he could make some headway on at least gaining some eligibility so that we could maybe amend some of the charges. I think Mr. Potter has an update that I just want to make sure that we get on the record. I know he did do some things, that we really get some things cleared, so I just want to make sure that he says that.
Mr. Potter, what have you accomplished
So
regarding driver's
the
license?
reason that the suspension, the revoke is there, but the reason I was unable to get my hardship license eligible was first was because of child support. And I have custody of my daughter. I explained all of that last time. Just waiting on the Department of Revenue judge to set a court date to reverse it because he signed it into order.
I understand.
And I've also, they've lifted their suspension from them, awaiting a court date. But I've also got a piece of paper with other monetary obligations through the clerk as well, and I've got that number, and I asked the state he gave me a continuance to give me another 2 months and come back in March, and he said he didn't see any problems with that, and I can get the monetary value taken care of and try to get eligible for a hardship.
Good, Mr. Potter. Then I'll see you back on March 13th at 9 o'clock.
Yes, sir.
I want to put it on the record if he does that, and he is able to come in and show eligibility, then we would be willing to reduce this like a misdemeanor, no valid, or something along those lines, so that it doesn't affect anything going forward.
Okay.
Awesome. Quick question on that. Just, of course, hardships, get a hardship takes an extreme amount of
If
time.
you just show me that you're eligible,
Eligible.
that's what I'm looking for. I
Okay.
want you to handle
I just
everything.
wanted that to be stated in there.
Good. Thank you, sir.
Yes, sir. Thank you.
Stephen Sequeria.
Judge, Mr. Sequeria actually was instructed by Officer Barres this morning, so I think we can remove him from the docket. My understanding from speaking with probation is that he was accepted into the PTI program.
Okay, so PTI. Mitchell Smedley is an inmate, so we'll see. Mr. Smedley.
This is just a fugitive from justice, and my understanding is the hold from Alabama was dropped on December 12th.
On Mr. Smedley?
Yes, Judge.
Okay, so he's not in county jail? He isn't?
He may still be in the county jail,
Okay,
but
let's see if
as
the
far as
judge-
fugitive from justice issue.
Okay. Taj Smith?
Judge, if we may go back to Stephen Sequeira, were you saying he was in the PTI?
PTI.
Yes, ma'am. Do
He
you
was
want to
accepted
just?
this morning.
Okay, can we set a control date so we can receive the paperwork?
That'd be fine, yes, ma'am. Hello, Mr. Smith.
How you doing, Your Honor?
Good, how are you?
Doing good, doing good.
March 13th? So 22 CF 2468. Does the state have an offer for Mr. Smith?
Judge, we had sent a PTI agreement to Mr. Smith in November 29th.
Never received it. Never received it. I checked my email, went through it, I didn't get it.
Okay. Can you send it to him via email?
That's what we did. Is this still the right email address? You may want to check your junk folder. Because maybe it just didn't come directly to you. You need to call and check your
I didn't receive, but I can check, but what's the step can we do? If it's possible, can I get like some more time to work on it?
Do you want, is there a way that Mr. Smith, if he comes back next Tuesday, that he can physically, you can hand that to him, or how do we make sure that he has it?
We can't, let's see that I have a copy in here. It would have just been straight through the email. Get the information from probation to meet with Officer Barres, and we'll send it directly to her.
Thank you.
Okay, so wait, so you'll be back here,
We just set it for a control date for March 13th.
okay, so March 13th at 9 o'clock, unless probation tells you you don't have to be here.
Okay.
Thank you, sir. Okay, that was all I had on the pro se docket.
That was all I had in the gallery that was here.
Right, and then you have folks that are waiting on inmates, and we've got Teresa, right? Okay, you want to start with the folks? Well, we got to go through the jail's got to call the docket, basically, right?
Yeah,
Okay. And we don't have the jail, do we?
No, they do have two people in the courtroom at this point. If we're going to wait, call them and call them out.
Oh, here we go. Okay, yes, sir, Mr. McKinney?
Judge, I have Mr. Rudolph, who's in the courtroom,
Okay, Mr. Rudolph?
and I have Ms. Rice, who the court had just issued a capias for.
Okay,
Mr. Rudolph is approaching 22 CF 2613. We've reached an agreement with the state. Mr. Demetrius Rudolph has signed a written plea agreement, in which case adjudication is going to be withheld. He'll be placed on 24 months probation. Special conditions would include a substance abuse evaluation, 25 hours community service work with the option to buy out, $615 in court costs, $150 cost of defense. Mr. Rudolph is currently seeking employment, so we would ask the court for the cost of supervision to be waived for all or a portion of the supervision if the court would be so inclined. May I approach?
Yes, sir, thank you. Mr. Rudolph, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. Mr. Rudolph, did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
Mr. Rudolph, I do accept your plea. Adjudication is withheld. You're sentenced to 24 months probation. You'll need to submit to a substance abuse evaluation within 30 days from today. Begin any treatment if it's recommended within 60 days from today. Perform 25 hours of community service work. You can buy that out. All monetary assessments mandated by statute or county ordinance are imposed. That's the court cost. $150 public defender's fee. Mr. Rudolph, how much money, you're unemployed? How long have you been unemployed?
Since last February or March.
So almost a year?
Yes, sir.
Why can't you work?
I was working, but it wasn't like everyday job type of thing.
Understand. Mr. Rudolph, I waived the cost of supervision for the first 3 months, but you'll need to pay it after that.
Yes, sir.
Okay? Thank you, sir. God bless you.
Probation on the way out. Judge, I have a Randall Rice in the courtroom. Ms. Rice? Ms. Rice is here in 22 CF 2125. Judge, she got her court date mixed up, but she's here now. The court
Good.
just issued a capias.
Ms. Rice, the capias is withdrawn.
I'm sorry.
So they won't arrest you. The capias is withdrawn. Okay? That's a good thing.
Yeah, it's a good thing. They're not going to arrest you.
Okay, thank you. I
Yes,
came as soon as I found out all the way from Miramar for my job. I didn't realize it was today.
Judge, can we come back on docket day for likely entry or change of plea at that time?
Okay.
Ms. Rice has got a day off tomorrow, and she's going to come in and talk to me tomorrow at 10 a.m.
Yes, sir.
Okay. Ms. Rice, I'll see you back here a week from tomorrow at 9 o'clock. Okay?
Yes, sir. What day is
The
that?
17th.
The 17th is a Tuesday at 9 a.m. You're going to come see me tomorrow at my office
Yes,
at
sir.
10. Okay?
Thank you, ma'am.
Thank you, Judge.
Thank you, Your
Thank you.
Honor.
Okay. No other defendants in the gallery, I take it? Okay, to the jail, who do you have? You want to just go down the list, or I know that Teresa's here as far as the interpreter. What do you?
Let's go down the list, yes, sir.
I have
Right.
Okay,
I have two, Your Honor.
if you can move. Okay, go ahead. Yes,
I
ma'am.
have one with Mr. Catalini.
Okay.
On the list is number 100, which
Okay.
is Morales Santiago.
Okay.
And with Mr. McKinney, I have another one, Padilla Barahona, and that's number 47 on the list.
Okay, so 47 and 100.
100.
Okay, thank you. So jail, if you can move those up, that'd be great. Okay, yes, ma'am. What's your name?
Leslie Ray.
Okay, Miss Ray, let me find a list. I know I've had multiple ones. Yes, ma'am.
Judge, Ms. Ray is my client in 22 CF 2513. I'd like to bring this back on docket day. There is a pending evaluation that I anticipate that we'll have in hand by the time we get the docket day.
Okay, Miss Ray, that means that I'll see you a week from tomorrow, okay? And it's plea continues, so I'll see you a week from tomorrow. Thank you.
Thank you.
Are you Miss Gore? I'm sorry?
Hello.
Hello? Miss Gore has private counsel, I think. Mr. Stevens?
I was just appointed to her case last week. I'd like to be set for docket day to receive discovery and get a chance to go meet with her, see if we can resolve it on docket day without speeds.
Okay, so please continue, Miss Gore. That means that I'll see you a week from tomorrow, okay?
Okay, so Tuesday?
Yes, ma'am, and Mr. Stevens will come talk to you.
Okay, thank you.
Thank you. Are you Miss Gilbert?
Yes, sir.
Who?
Good afternoon.
Mr. Noakes?
I was appointed to Ms. Gilbert's other two cases, and then she got a trafficking case. I got discovery last week, got it printed out. I did not get a chance to go to the jail to talk to her about it, but since it is a trafficking case, which carries a minimum mandatory, I believe it would be best just for us to set it in March, and I'll go out and review it with her and figure out what depots, if any, we're going to take.
Okay. Ms. Gilbert, do you understand what Mr. Noakes just stated?
Yes, sir.
Okay.
Yes, sir.
So, Ms. Gilbert, I'll see you no later than March 13th, but if Mr. Noakes sets a motion hearing before that date, I'll see you then, okay?
All right.
Thank you, ma'am.
Thank you.
You're out?
Yes, sir.
Who represents Ms. Urat?
I do, Judge.
Okay.
Yes, sir. Good afternoon.
Evidently, we're going off a whole new list here. So Ms. Urap is my client. I'd like to come back on docket day. Ms. Urap, I have received an offer from the state, which I need to review with you. But the basic terms, so that you're in the same loop as everybody else here, is that the state would be willing to accept a plea for an 11-month, 29-day sentence in the Okaloosa County Jail, followed by 10 years of probation. That is serious enough that I certainly want a full opportunity to discuss that with you at the jail, and we'll do that prior to us coming back on the 17th, next Tuesday.
Yes, sir. Thank you.
So I'll see you a week from tomorrow, okay?
Yes, sir. Thank you.
Thank you, ma'am. Mr. Klein?
Yeah, I'm gonna screw her name up, but this is Kara Olszewski. We're gonna ask to leave Ms. Olszewski on for plea or continue for next Tuesday. We are trying to negotiate a time, some type of a county jail sentence for Ms. Olszewski. So I would like to, and I talked with Mr. Gomez, we'll probably be able to get it done. I don't want to just kick it down the road 2 months.
Good. I'll see you a week from tomorrow, okay, ma'am?
Okay, thank you.
Thank you.
Kara, I'll come up to the jail sometime this week and talk to you, okay?
Okay, thank you.
Next.
Sure, this is Morgan Rebel before the court in 22 CF 2521. The state has agreed to our counteroffer of 90 days county jail. However, there are some credit issues that are kind of particular, so I'd like to do this in writing, and Ms. Rebel won't be eligible for release before Tuesday anyway. So I'd like to just set it for Tuesday so we can get it resolved then.
So plea a week from tomorrow.
Yes, sir.
Ms. Rebel, I'll see you a week from tomorrow, okay? Thank you, ma'am. You, Ms. Walker? Who represents Amanda Walker? Or I'm sorry?
No, this one, Lucchese. Yeah.
Oh, Lucchese. Okay, Ms. Lucchese, thank you.
Your Honor, this is Ms. Lucchese. We're going to ask the court for a one-cycle continuance. We filed a motion, but we did not have deposition dates when we filed the motion. I still probably don't have deposition dates. I would imagine they're going to take place in March, but we were just appointed to the case. She just had plea day. We would ask the court for a one-cycle continuance.
Okay. Ms. Lucchese, I'll see you no later than March 13th, but if Mr. Klein sets a motion before that date, I'll see you then, okay? Thank you, ma'am. Are you Miss Randolph?
I'm Dana Wilson.
Hello, Miss Nelson. I didn't think that was your name.
Ms. Randolph was taken off the docket.
Okay, thank you.
Your Honor, this is Dana Melson. We have deposition scheduled in February for Ms. Melson's case in 22 CF 1855. Based on that, I'm going to have to ask the court to continue this so we can get those depositions taken.
Okay. Ms. Melson, I'll see you back here no later than March 13th.
All right, you have a good day.
Thank you, ma'am. You too. Ms. Villanueva?
How are you doing?
How are you doing?
Judges, Judge, she is my client. May I have just a minute with the state?
Yes, sir.
Case Villanueva is before the court in 3 cases, 22 CF 2737, 22 CF 2739, and 22 CF 1671. I did not realize or see that she came up so early in the list here, and I don't want to bring her back today given the moving pieces. So if we could have just 1 minute with the state to see if we can resolve this today. If not, we'd come back to docket day.
Okay, and we're going to have to take a recess. Would this be a good time to do it?
No, sir, if we could
Okay.
just keep plowing forward.
Okay.
I'll defer to scheduling it to the courts. Judge, let's just put this on docket day. Ms. Villanueva, I still need an opportunity to discuss this with the state based on the counteroffers that we had talked about. And if we are entering a plea to 12-1 or anything Department of Corrections, Judge Brown's going to want to likely do that in person rather than on Zoom. Let's come back on docket day, which is next Tuesday, and then I'll come meet with you again and we can go over the final offer from the state.
Yes, sir.
So, Ms. Villanueva, I'll see you a week from tomorrow, okay?
All right.
Thank you, ma'am.
Judge, this is Maria Rodriguez Barnes before the court in 20 CF 801. We had steadily been making progress in her case. Michelle Sandgate is the state attorney assigned to this case. We completed the last round of all-day depositions on the 21st of December. That's going to lead us to additional depositions that are needed that we're scheduling in Pensacola. Given the amount of moving pieces, this case is not ready for trial this time. We're trying to line this up realistically for the May court cycle if all goes well. So I'm going to be requesting a continuance today. I do not want to push this all the way to that cycle. I'd like to put hands on it on the pretrial court date in March.
Okay. Ms. Rodriguez Barnes, I'll see you back here on March 13th, okay?
Yes, sir.
Thank you.
Yes.
It's going to be a few minutes, Chairman. We're trying to get people here.
Okay, then why don't we take a 10-minute recess and then we'll come back and finish up the afternoon?
All right.
Mr. McKinney to save the day. He is,
Good afternoon, Judge.
Buenas tardes, juez.
Judge, this is Mr. Padilla Barahona,
Señor juez, este es el señor Padilla Barahona,
case number 21CF138.
en el caso 21CF0138.
The court last saw Mr. Padilla Barahona at a hearing related to a witness.
La última vez que la corte vio al señor Padilla fue en una audiencia relacionada a uno de los testigos.
Where the court excluded the confidential informant.
Y la corte excluyó al informante confidencial.
At this time, we are seeking a disposition or some finality to his case.
En este momento estamos esperando una conclusión o algún tipo de disposición en este caso.
So we would like it to remain on the trial docket.
Lo vamos a dejar en el listado de casos que van para juicio.
To the state.
Al Estado.
We would agree with that, Your Honor. We want by plea dismissal or trial in the cycle.
Estamos de acuerdo, su señoría. Vamos a dejar este caso programado, ya sea para retirar los cargos o para llegar a algún tipo de arreglo.
Mr. Padilla Barahona, that means that I'll see you a week from tomorrow.
Señor Padilla, eso significa que lo voy a ver en una semana a partir de mañana.
And then we'll be looking at going to trial on January 23rd.
En esa fecha vamos a ver para ir a juicio en enero 23.
Thank you, sir.
Está bien, está bien.
That's very good. Thank you very much.
Okay. La corte sería en Fort Walton.
So the court is going to be in Fort Walton?
Yes, sir.
Sí, señor. At what time?
On January 17th, it will be in the morning.
El 17 de enero va a ser en la mañana.
And then we'll schedule a date for January 19th for jury review.
Entonces programamos otra corte para el 19 de enero para el registro de jurado.
And then the trial will either be January 23rd or February 6th.
Y el juicio va a ser programado para el 23 de enero o para el 6 de febrero.
But I will see you a week from tomorrow.
Pero nos vamos a ver en una semana a partir de mañana.
Muchas gracias.
Thank you very much.
Mr. Padilla Barahona, you'll be transported to the courthouse for the 17th.
Señor Padilla, usted lo van a transportar a la corte el 17 de enero.
Okay, gracias.
Thank you.
Mr. McKinney, who is this? There you go.
Good afternoon, Your Honor.
Buenas tardes, su señoría.
Your Honor, before the court is Mr. Juan Morales Santiago.
Su señoría, frente a la corte está el señor Juan Morales Santiago.
Your Honor, case number 22CF420.
En el caso 22CF0420.
Your Honor, this is the first time up. I'm sure there's no objection by the state to continue it.
Su señoría, es la primera vez que estoy frente a la corte con relación a este caso y estoy seguro que la fiscalía no tiene ninguna objeción en continuarlo.
So, Mr. Catalinic, what are you going to do over the next 2 months regarding the case if the court grants the continuance?
Your Honor, we're still waiting for this.
Señor Catalini, ¿qué va a hacer usted para progresar este caso en los próximos 2 meses?
Your Honor, we're still waiting for the discovery. It's a very serious matter. We're going to be doing depositions over that time as soon as we can get that.
Su señoría, estamos esperando todavía la evidencia y tal vez tenga que programar deposiciones. Los cargos en contra de este acusado son bien serios.
It's a brand new case, sir. It's the first pre-trial.
Y es un caso nuevo para mí y esta es una audiencia preliminar.
The motion for continuance is granted.
La moción para continuar es concedida.
I will see you back here on March 13th.
Nos vemos otra vez el 13 de marzo.
Thank you, Judge.
Thank you, Mr. Catalinic.
Gracias, señoría. Gracias, señor Catalinic. Thank you, Your Honor.
Thank you, Teresa.
Okay, Lucas. Myers.
Joe, we don't have a video feed for you, just so you know.
I don't know what happened, sir. It just went away. I don't know what, we didn't do anything different.
You want to log out and log back in?
Sure.
Okay. I'm sorry.
Judge, this is Mr. Rubens.
Thank you.
Judge, I represent Lyle Rubens in 22 CF 2232. He met with Dr. McDonald last Friday. I'd like to come back on docket day. I don't want this moved all the way to March. I'm going to try to get a report in hand prior to us coming back on docket day.
Mr. Rubens, I hope to have that report before next week, so I'll see you a week from tomorrow, okay?
After what? They're gonna bring you back next week to the court. Okay? Thank you.
Thank you, sir.
Next. Or he's ready to go back. Did you have? Did you ever start your management?
You're Mr. Rogers?
Yeah, how you doing?
Thank you. Who represents Mr. Rogers?
I do, Judge.
Thank you, Mr. Stevens.
Judge, this is another new appointment for me. I did receive discovery, still going through it. I'd like to set for docket day if the court would entertain a bond motion on that day.
Okay. Madam Clerk, how busy is the afternoon of docket day?
For next week, there is one set at 1:30.
Okay. And we don't have arraignments on the 17th. We do not. Mr. Stevens, we can set it for 1:30 on the 17th.
That works. I'll get the motion filed.
So I'll put plea continue, and then you'll have that motion.
Yes, sir.
So, Mr. Rogers, I'll see you next week, okay?
Yes, please, sir.
Thank you, sir.
Next. You want this? Yes.
Judge, this is Christian Rivas.
Thank you.
Mr. Rivas is here in 22 CF 826, and I received score sheet that I need to send to Phoenix so they can give me an answer on whether or not he's appropriate for placement. So I'm going to ask that we come back on docket day, as I should have an answer from Phoenix House by the time we come back to docket day.
Okay. Mr. Rivas, I'll see you a week from tomorrow, okay?
Yes, sir.
Thank you, sir.
Nicholas.
Hello, Mr. Nichols.
How you doing, sir? Is Scott Klein's present?
Yes, sir, he is.
Hey, Mr. Scott Klein's, wait till today, talk.
Your Honor, this is Eric Nichols. We are trying to get this worked out with the state. One of Mr. Nichols' big concerns is this no contact, no trespassing at his grandfather's residence. Mr. Gomez with the state has not had a chance to talk with the people involved to find out if that can be changed. I would ask to leave Mr. Nichols on for plea or continue next week. Hopefully we can get a resolution next week.
Okay. Mr. Nichols, I'll see you a week from tomorrow, okay?
Yes, sir, may I have a word?
Yes, sir. Just know that everything's being recorded, so I wouldn't say anything factually about your case, okay?
Yes, sir. My mother told me that I can live at her house at 4250 Hicks Road. And I would like to take this probation offer.
Oh, today?
Yes, sir.
Okay.
With the hopes of, after everything's done, I'd get a suspended sentence.
Okay,
Not a
let's
suspended sentence, a early termination on my probation.
Drastically different things.
Yes, sir. I understand that it was I'm not new to this stuff. Once all my classes are done, I'd like the early termination, if possible.
What is the offer from the state for Mr. Nichols?
It's
Hold on one second. Let the state.
Your Honor, I believe this was an offer that was relayed before I ever got on the case, and I told Mr. Klein's that I would honor it, so Mr. Klein's would actually know the offer.
Okay, Mr. Klein's.
I am going through the discovery right now, Your Honor. I gave my copy of discovery to Mr. Nichols last week when I was talking.
Okay, Mr. Nichols, do you have that piece of paper with you?
Yes, sir, I
Good.
do.
Why don't you read what the offer is?
Standard probation 5 years, restitution of the amount to be determined, $967 assault.
Court costs.
Court costs, $100 public defender fee, 100 hours community service, no contact with the victim, BIP, AMC enroll within 60 days.
Mr. Nichols, that means batterer's intervention program, okay? That's like an anger management program.
Yes, sir, and no trespassing on 1026 47th Street, and maintain employment, or put applications in 3 times per week. If I can't get the trespass off my papa, I would like to handle that on the outside.
Okay, so Mr. Nichols, is that what you wish to accept? You want to accept that offer, 5-year probation with the restitution?
Yes,
okay.
And Your Honor.
I'd be residing at 4250 Hicks Road, Crestview, Florida. I wish to have Crestview probation.
Okay, just importantly, Your Honor, that offer requires an adjudication. Mr. Nichols has one prior for no valid driver's license. I have gone over the pros and the cons of an adjudication. Well, there's really no pro of an adjudication, but explain the possible downside. We talked about this for probably 5 or 10 minutes at the jail last week. The state is going to insist on an adjudication, so if Mr. Nichols wants to accept it, he's going to have to be aware that that's going to require an adjudication.
Okay, so Mr. Nichols, here's what I hear is that you haven't previously been adjudicated guilty of a felony. If you accept the plea, you would be adjudicated guilty of the felony and then sentenced to that 5 years probation. Is that what you wish to do?
Yes, sir, it is. I would hope within 7 to 10 years that I could write a letter to the judge to get my gun rights back.
Yes, sir.
If possible.
Mr. Nichols, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
Thank you. You can put your hand down. Mr. Nichols, so do you understand that, first off, do you understand everything that was stated today? You were the one that stated what the terms of the probation would be, the batterer's intervention program, and those other terms. Do you understand those?
Yes, sir, I do.
Do you understand that you'd be waiving your right to a trial by jury?
Yes, sir, I do.
Do you have any questions for the court or your attorney or the state about the plea agreement?
Am I eligible for early termination if I complete all the requirements?
There's no agreement with the state, but the court can always grant an early termination if the court determines that it's appropriate.
Thank you, Mr. Brown.
So you do wish to enter the plea, Mr. Nichols?
I wish to take this probation, yes, sir.
Okay.
The last thing I'll add, Your Honor, just so the record's clear, I talked with Mr. Nichols, I explained this is a negotiated downward departure. If there's a violation of probation, it will almost certainly have a presumptive DOC sentence. And furthermore, Your Honor, this particular charge would qualify Mr. Nichols for violent felony offender special concern designation. I explained how that might affect him. Obviously, the plan is not to violate, but just in case, he's aware of that designation and the presumptive DOC sentence if he violates.
Okay. So, Mr. Nichols, if you violate probation, the court's not going to be able to allow you to post the bond. So you're going to be sitting in jail until your case is dismissed. Do you understand that?
Yes, yes, sir. Is that even with the technical?
Yes, sir. It's any violation. Correct. So you'll be sitting in jail until the violation of probation is disposed of.
So any kind of violation, I'm going to do 34 months?
No, you're just going to be sitting in jail until there's an adjudication of the violation of probation. I can't tell you what the sentence would be because I don't have all the facts yet. You could be sentenced up to the maximum, but just know in the short run you won't get out of jail because you can't get a bond.
Yes, sir. I got one more question, Mr. Brown.
Okay.
The 5 years probation, if I was to make it 2 or 3 years into this probation and I was to violate, am I gonna do 5 years?
I can't tell you what the sentence would be.
Yes, sir.
Okay. I mean, you could do up to the maximum. It just depends on all the circumstances at the time of that sentencing. So I can't tell you what you shall be sentenced to, but I can just tell you what the maximum is.
Yes, sir.
Do you still wish to enter the plea?
Yes, sir. Thank you.
Mr. Nichols, I do accept your plea. You're adjudicated guilty. It is a downward departure based on a negotiated plea. You're sentenced to 5 years probation. The court does award restitution, but reserves jurisdiction to determine the amount of that restitution. You'll need to enter and successfully complete the Patterns Intervention Program, have no trespassing at the address that you previously stated, no contact with the alleged victim. You'll need to pay the court costs, the $150 public defender's fee. You'll need to perform 100 hours of community service work, maintain gainful employment, or have 3 job applications per week. Thank you, Mr. Nichols.
Thank you for your time, sir.
Thank you.
Mays, all right, Mays, what's your name? Jake Mays.
Your Honor, this is Jake Mays, 22 CF 2429. We're going to ask the court for a 1-cycle continuance. We do have Mr. Mays in the deposition pipeline, so to speak. This is count 3 in this case. Does carry a 25-year min-man sentence. So we are going to ask the court for a 1-cycle continuance so we can take those depositions. I imagine there's going to be some motions filed after those depositions.
Okay. Mr. Mays, I'll see you back here no later than March 13th. Thank you, sir.
All right, thank you.
Your Honor, this is Donald Douglas. I talked with Mr. Rogers with the State Attorney's Office this morning. He was the individual with their office who was taking the deposition of the defense witness. We had issues. We haven't had a chance to reschedule that particular deposition yet. I would ask the court, I guess, to ask for a joint continuance so we can get that deposition taken. Donald, for your benefit, I did talk with Mr. Rogers, and he is going to be looking at the gun issue, for lack of a better way of saying it. So if we do get some kind of a resolution, we work this out with the plea or something, we'll get you back in front of Judge Brown before your next court date, if at all possible.
It is a joint motion, Your Honor.
Okay. The joint motion for continuance is granted. Mr. Douglas, I'll see you no later than March 13th. Thank you. You too.
Your Honor, this is Marcus Coleman. I did get a chance to go over the authority that Mr. Coleman gave me in court last time. We are going to announce plea or trial. There has been an offer made by the state. Mr. Coleman is well aware of that. It would dismiss 2 counts. If you pled to 3 others, it would involve 6 years in the Department of Corrections, followed by essentially 10 years of sex offender probation. So I'll come back up to the jail this week, Marcus, and we'll talk about what you want to do next Tuesday, okay?
Mr. Coleman, hold on 1 second. Does the state intend to withdraw that offer if Mr. Coleman doesn't accept it next Tuesday?
Yes, Judge, that offer will be revoked at docket day, and we'll be filing a motion for the juvenile he solicited will out on bond.
Okay, I'm sorry.
We'll be filing a motion to introduce the juvenile he solicited will out on bond for this case as well.
Okay.
If the offer is rejected.
Okay, so Mr. Coleman you just lost the jail again? We don't have him audio or video. Jill, we can't hear you. Your mic's muted, and we can't see you. There we go.
We have audio. I'll restart it.
Okay, thank you.
Technical difficulties.
Okay, thank
We
you.
see you. We see you.
Okay, on Mr. Coleman's case, I'll just see him on a week from tomorrow.
Okay? We from now. I'm going to continue this. Okay? If I will, when I have to restart again, we have our IT people trying to work on it.
Thank you, sir.
Aaron, while we wait for them, I did file a waiver for Tavares Gainer. He's not on the transport list.
Yes, sir.
I would ask the court for a one-cycle continuance for Mr. Gainer. Mr. Rogers and myself are in the middle of taking depositions. So we would ask for a one-cycle continuance for Mr. Gainer.
Mr. Gaynor's case is continued. Hello again, jail.
All right, next.
Is it Meyer?
Yes, sir.
Thank you.
Your Honor, David Rare for the record, I'm here to Mr. Christopher Meir. Mr. Meir, I received a new offer from the state today, so I need to relay that to you now. The agreement from the state today, I believe they would dismiss the grand theft auto charge. You would enter a plea of no contest to the misdemeanor suspended license charge. There would be a withhold of adjudication, meaning you're not formally convicted, so there's no funds on your license, and a $300 court cost, which you'd have about 90 days to pay. Do you want to do that today?
Yes, sir.
Okay, Mr. Meir, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand down. Mr. Meir, do you understand that if I accept your plea, that you're waiving your right to a trial by jury?
I do, Your Honor.
Do you wish to accept the plea?
I do, Your Honor.
Mr. Meir, I do accept your plea. Adjudication is withheld to the misdemeanor. You need to pay the $300 in court cost. You were privately hired, right, Mr. Ray?
Yes, sir.
Okay. Mr. Meir, how long will it take you to pay the $300 in court costs?
Hoping to find out tomorrow morning, or not by the end of the week.
Okay, why don't we say 30 days, okay?
30 days, yes, sir. As long as I'm released, which I should be. Yes, sir.
Okay, so if you fail to pay it within 30 days, then it will go to a civil judgment. Thank you, Mr. Meir.
Thank you, Your Honor.
And Your Honor, for the record, Mr. Gomez announced the null cross of count one on the record, just so the record's clear.
Yes, sir.
Your Honor, the state announces a null cross on count one.
Thanks, Mr. Ray.
Thank you, that's all I have, Your Honor. Thank you.
Okay, Mr. Good.
Thanks.
Thank you.
Judge, this is Mr. Adam Young before the court. Mr. Young is before the court in 3 case numbers, 22 CF 2886, and violations of probation in 22 CF 2473 and 22 CF 1515. Mr. Young, I have been unable to get a better offer than the guidelines of 18.2 months like we discussed at the jail. I'm going to suggest that we request a continuance until the March date so that I can complete depositions in the new case. That would bring you come back to court on March 13th.
Mr. Young, do you agree to the continuance? Do you understand what Mr. McKinney wants to do between now and March 13th? He wants to take depositions and prepare for your case better?
Yes, sir.
I think if we came back to court like we had talked about on Docket Day, that the 18-month offer is still going to be the position of the state attorney, and that we're going to be seeking to do depositions at that time. So I would suggest that we go ahead and request a continuance today so that I could go ahead and get the depositions scheduled.
So, Mr. Young, I'll see you no later than March 13th, but if your attorney sets either if you want to enter a plea before that date, or if your attorney files a motion, then I'll see you before March 13th. Thank you, sir.
Judge, this is Ryan Thomas before the court in 22 CF 1891. The last time we saw Your Honor at pretrial, we told the court that our depositions were scheduled on the 31st of this month, so we left the date on primarily as just a status. We still need to complete the depositions for Mr. Thomas, so I'm going to formally request a continuance today.
Okay.
Mr. Thomas, as soon as we get those complete, then we'll review that at the jail.
Mr. Thomas, I'll see you no later than March 13th. Thank you, sir.
Yes.
Taylor.
Yeah, this is Gordon Taylor. We were going to announce ready for trial for Mr. Taylor in 22 CF 54.
Okay, is the state ready for trial in that case?
Yes, Judge, I will need to confirm with my witnesses that came down with.
Okay. Does the state intend to withdraw an offer to Mr. Taylor if he doesn't accept it a week from tomorrow?
Judge, at this point, Mr. Taylor has already been found guilty of a violation of probation, so I think we're already past the point of plea negotiations.
Okay, so there's no plea offer to Mr. Taylor?
Not at this time.
Okay. Mr. Taylor, I'll see you a week from tomorrow, and we'll be looking at going to trial at the end of the month.
This is,
Okay.
this is on the 54 case.
Correct. The violation of probation cases are just tracking along with that case number. And then after this case number is resolved, then we'll come to the court for sentencing.
Okay. Mr. McKinney?
Mr. Weathersby? Mr. Weathersby is before this court. The court signed an order last Friday that transferred him back to this division. I've met with Mr. Weathersby. I'm aware of all the moving back and forth. So Mr. Weathersby, I'm definitely going to be your attorney. You're definitely going to be here with Judge Brown for the remainder of your case. Based on our last conversation, we do need to set depositions, and I'm going to request a continuance. Now, given the amount of bouncing around that you have done between Crestview and here, do you want to come to court on the 17th, basically a week from now, to see Judge Brown in person, or would you like for me to continue the case until March 13th? We're going to need to set depositions either way.
Yeah, I'll wait till March because I also need to get my discovery.
Yes, sir. And now that we know that it's going to be me as your attorney and Judge Brown as your judge, then we'll go through that. I told you I'd get you a copy if that's how it came down. I'll do that.
Yes, sir.
Mr. Weathersby, I'll see you no later than March 13th, okay?
All right, Your Honor, have a good day.
Thank you, sir. You too.
And just for the record, I do show that this case was actually set for Thursday, I believe, for felony plea day, because it never went to plea day.
So do you deny?
We would enter a written plea or plea not guilty to the charges and waive any formal readings. So that would take him off of felony plea day, and then we'd keep him on the plea trial on the March 13th date.
Thank you.
Judge, this is Sean Tillman. Mr. Tillman is before the court in 22 CF 1348. He also has a violation of probation that's tracking along in 18 CF 2512. This is a case that we announced that we were ready for trial in last cycle, which was continued by the state. We're announcing ready for trial again.
Okay, to the state. Tillman?
Sean Tillman.
Yes, sir.
Mr. Tillman, the state was just asking your name where they could find your file.
I've got the duty phone, Judge. So I'm a little all over the place. Judge, tentatively, I'm okay with planning for trial this cycle. I know one of my victims was out of town, is working out of town, so I just need to make sure which date that they're going to be available, if we need to do it the first or second week.
Okay. So, Mr. Tillman, that means that I will see you a week from tomorrow, and we'll be going to trial either the week of January 23rd or the week of February 6th. But we'll know more on January 17th, a week from tomorrow, okay?
Yes, sir.
Thank you, sir.
Thanks. Yeah.
Judge, this is Mr. Rayshawn Starks before the court in 22 CF 2924. We're still awaiting discovery from the state in this case. I would like to come back on docket day, plea or continue, and I'd ask for the opportunity to be heard with a bond motion at that time if we have not made progress in the case.
Okay. So you want me to see Mr. Starks at 1:30 a week from tomorrow?
Yes, sir.
Okay.
And if I file a bond motion, may we schedule it for docket day?
Yes, sir. So Mr. Starks, I'll see you a week from tomorrow at 1:30, okay?
All right, thank you.
Thank you, sir.
That's you, Mr. Walker.
This is Mr. Snyder. Jonathan
Yes, sir.
Snyder?
Yes, sir.
Mr. Snyder has two cases. One is on this docket, and I believe there is a second case, 22 CF 3116. Madam Clerk, can I ask if the information has been filed in the new case?
May I have a case number again?
22 CF 3116.
And how many counts is that? Just the 2 count? Judge, we would enter a plea of not guilty in 22 CF 3116. And then I'd ask for both of these cases to be brought before Your Honor on docket day on 117. If we could advance the 3116 case, not for trial, but to try to resolve the matter.
Plea continue on both of the cases. Mr. Snyder, I'll see you a week from tomorrow.
Yes, sir. Thank you.
Thank you.
Next.
Your Honor, can I recall Michael Lyon, just really briefly?
Okay. Jail, if you hold on 1 second, Mr. Lousy. Yes, sir.
Your Honor, this is Mr.
Lyon.
Lyon. He was ordered to wear a GPS monitor earlier today. He is asking the court if the court would order $1 a day GPS monitor. He's only working 3 days a week, and he's got health issues. So he had come back to court to ask to see if the court would consider that.
Mr. Lyon, how much money do you make per month?
I can't tell you because of the holiday season, and I'm going to have surgery on my foot, and I'll be down for like 9 weeks after that.
Okay. How much were you averaging making per month before the season?
I think about 1,400.
Okay. Mr. Lyon, I do grant your motion for it to be $1 per day on the GPS monitor. Thank you, sir.
Thank
Yes,
you.
sir.
Your Honor, this is Kirk Losey. We did get the evaluation report from Dr. McDonald. Mr. Losey looks like he is good to go. I did meet with him at the jail last week to tell him that the report came in. He indicated he would like to ask for a Feretta hearing. I'll pass it to the court for the court to determine how you want to handle that.
Okay. First off, when you say, Dr. McDonald, there was a competency evaluation?
There was, Your Honor. She found him competent to proceed. I believe we had emailed Ms. Falk that last week. I think. I did not personally, but. I have a copy if you'd like it.
Yes, sir. That would be better. Thank you. Please. Thank you, sir. court does find Mr. Losi competent to proceed.
And I know Mr. Losi would like to ask the court for a Ferretta hearing. I don't know what the court.
Has he made that in writing?
You'd have to ask Mr.
Mr. Losi, did you ask to represent yourself in writing? Have you done that in writing? The microphone's muted, Joe. Mr. Losi, the answer was yes?
Yes, sir. I've filed several motions with the court.
Okay, and there's only a couple that the court would take recognition of with you represented by counsel. One of those is the Ferretta. So, Mr. Losi, since we have about another probably 60 or 70 folks for today, I'll set your motion hearings for a week from tomorrow. Well, do we have time this Thursday? What does it look like this Thursday afternoon?
Set at 2:30.
Okay. Mr. Losi, I'll see you this Thursday afternoon at 2:30 for those motion hearings, okay?
Thank you, sir.
Thank you, sir.
Judge, just so the state's clear, what motions are you going to be hearing on that date?
I think it's just Ferretta.
If he's filed a Ferretta, then I'll do that. Yes, sir.
Your Honor, this is Chad Long.
Yes, sir.
This is Chad Long in 22 CF 2591. Mr. Long is currently on my deposition list. There are 17 witnesses that I am intending to take depositions on. I'd like to be optimistic, but I don't think that's all going to happen by March 13th. I would, at this point, ask for a 2-cycle continuance, and if we do have any motions between now and May, we'll get them back in front of the court.
Okay. Mr. Long, do you understand what Mr. Kleins is doing on your case?
I believe so.
You do believe so? Okay.
Yes, sir.
Then I will see you no later than May 8th, but hopefully Mr. Kleins will set some motions before that, and I'll see you then, okay?
Yes, sir.
Thank you, sir.
Next.
May 8th at 9 o'clock. Mr. Kleins, here's your paperwork.
Oh, I'm sorry.
Evaluation.
Thank you.
Thank you. Are you Mr. Whitley? What's your name?
Javier Savio.
Thank you, Mr. Savio. Yes, sir.
It's my fine judge. We've got deposition scheduled for January 18th, all morning. I think it probably would be best just to say continue the case. No sense in putting it on for Tuesday because the depots aren't until Wednesday.
Yes, sir. Mr. Savio, I'll see you no later than March 13th, okay?
Yes, sir.
Thank you, sir.
Thanks.
Mr. Luna?
Yes, sir.
Yes, sir. Who represents Mr. Luna?
That's me, Your Honor.
Thanks, Mr. Keach.
Judge, we were recently appointed in Mr. Luna's case. I spoke with the state early last week. We're still in the process of getting all the discovery. It is an FDLE investigation. It's a pretty voluminous file and multiple co-defendants. If I could have a continuance, just asking for 1 cycle right now so we can try to get in and see what all, obviously depositions will be involved and everything. And then I'll need to get out there and see Mr. Luna at the jail and meet with him as well. But I'd like a continuance.
Okay. Mr. Luna, I'll see you no later than March 13th.
Yes, sir.
Thank you, sir.
Thank you.
Oh. Hey, Cassiano, right? Is he on early this morning? Is he in the train from you know? Do we still need to send him out now? He went like super early this morning. Yeah, I do a good on that. Well, yes, we need him. Okay, so.
Yes, sir. What's your name?
Haley Jones.
Good. Thanks, Mr. Jones. Who represents Mr. Jones?
I do, Judge.
Thanks, Mr. Stevens.
Judge, he is Mr. Luna's co-defendant. Mr. Keach just continued his case 2 seconds ago. I'm also going to ask for continuance for the same reasons. We're still going through the discovery process, and the indictment came down since the last pre-trial, so we just got a little late working at this one.
Okay. Mr. Jones, I'll see you no later than March 13th.
All right.
Thank you, sir.
Oh, Chris, you can relax.
I'm freezing here. Clear.
Hello, Mr. Humphreys.
Yes, sir.
Judge, I also represent Mr. Humphreys. He has been transported back from Duval County. I spoke with him last week. We are going to leave 21 CF 1762 set for trial.
Okay, to the state, are you ready for trial on that case?
Yes, Your Honor, we will be. For the record, our offer at the moment is plea to the felony battery, adjudication of guilt, 1129 OCJ, credit for time served. I believe he'd be close to having that in. That's a non-sex offense. As charged, he currently he would score out to 145.5 months Department of Corrections. That would be to the lascivious battery and molestation as charged, and that does come with a designation. That would be revoked at docket day.
And Mr. Humphreys would get credit for the time he's in Duval County?
Yes, Your Honor, he would.
Okay. Mr. Humphreys, my job isn't to try to talk you into anything, and I'm not trying to do that, okay? But I just want you to know, did you understand what the state said their offer is to you?
Yes, sir.
To the state, it's my understanding it would be an adjudication of guilt, correct?
Yes, Your Honor, to felony battery.
Okay. So, Mr. Humphreys, your homework between now and a week from tomorrow is to talk to Mr. Stevens, determine whether you think it's in your best interest to accept that plea. If you say that you don't want to accept the plea, then we'll be going to trial in a couple weeks after that, okay?
Okay.
So I'll see you a week from tomorrow.
All right, thank you.
Thank you.
And Judge, I believe that's all I have. Thank you.
Thanks, Mr. Stevens. Mr. Gamble.
This is Nigel Gamble before the court. Mr. Dees represents Mr. Gamble on one case. I don't have that case number. I have two case numbers, 22 CF 2532 and 22 CF 2632. One of which is a refiling of charges that were null pros after the court denied the state a continuance because they didn't have, my understanding is the state was asking for continuance a couple days before trial because they didn't have their FDLE results. The court denied that continuance. The state ultimately filed a null pros based on that, and a few weeks later reinstated the charges and started a new case. Mr. Dees represented Mr. Gamble on that case for almost 2 years. My understanding is a significant amount of work and depositions need to be done on that case, or at least collected so that I can review them to determine if I need any additional depositions. There's also a new trafficking case with multiple FDLE results that will need to be obtained. So if Mr. Dees does not intend to resume representing Mr. Gamble on the case that the state refiled on, certainly I am going to have a significant amount of catch-up to do. Given all of the things that are going on, we can bring Mr. Gamble back in March, but I'm telling the court right now, there's no way I'm going to be caught up on all of that by March. So I would ask that the court provide us with a 2-cycle continuance to the May docket to give me an opportunity to at least figure out what's going on, where we're at, what's procedurally what needs to happen.
I understand. Any objection from the state?
No objection from the state, Your Honor.
Mr. Gamble, that means that I'll see you back here no later than May 8th, but if the hearing's set before that date, I'll see you then. Thank you, sir.
Thanks to myself, figure out stop. Stay out back there.
Mr. Woodard? Judge, Mr. Woodard is here in 22 CF 2504. Mr. Woodard, the state is still at a position where they are asking for a 12.1 month Department of Corrections sentence. Judge, I'd like for him to come back on docket day, plea, or continue to see if we can resolve the matter since he scores 43.4 points. I know that he was wanting me to ask the state for a probationary sentence. He's been incarcerated since he was arrested in September, but I'd like the opportunity to come back on docket day.
Okay. Mr. Woodard, I'll see you a week from tomorrow, okay?
Okay.
Thank you, sir.
Judge, this is Mr. Jamarius Warmble before the court. Mr. Warmble is here in 22 CF 2320. We've had depositions scheduled for the 31st of this month for a while now. I believe we talked to the court last time about that. So we set his date as a status date primarily to see where we're at with it. We still need to complete the depositions, Mr. Warmble, so we're requesting the continuance so that we may do so.
Okay. Mr. Warmble, I'll see you back here no later than March 13th. And then we'll be looking at going to trial at the end of March, okay? Thank you, sir.
Thank you. Wallace.
Judge, this is Mr. Nicholas Wallace. Mr. Nicholas Wallace is here in 22 CF 2340. We attempted to do depositions with the alleged victim towards the end of the year last year. We've since got a new address. We've got a reset for this Friday. So I'd like to come back on docket day to see if we're in a position to resolve the matter, to see if she shows up at the deposition this Friday or not.
Okay. Mr. Wallace, I'll see you a week from tomorrow.
Thank you.
Thank you, sir.
Judge, this is Mr. Turner before the court. Mr. Turner is present in 22 CF 1465. We just completed depositions at the end of the year, really, and we're trying to get Mr. Turner into the Jada house. I still have to get approval from the state attorney's office for us to do something like that, Mr. Turner. That's something that we've discussed. So we need to come back on the docket day, the 17th, to get an answer from the state.
So you want
docket day, plea, or continue?
Mr. Turner, I'll see you a week from tomorrow, okay?
Yes, sir.
Mr. McKinney, as you mentioned that, and I don't have the case with me because it's on my bench or in my chambers, but there was a case that came down about, I believe it was mental health court, and the appellate court said that the state, the court could not delegate its authority to the state to say whether someone qualified for mental health court. I've asked Judge Mason and Judge Schlechter, I've just asked them to look at that to see if that's broader. Is it broader than just that one court? Would it apply to other situations? So once I get that cite, then I will send it to the state and send it to you, just to see if the court has to defer to what the state recommends as far as some of those specialty courts.
Yes, I know there was a discussion with the courts related to drug court several years ago related to the same type issue, whether or not the state could act as a gatekeeper or not.
And this case was in April of last year.
Yes, sir. Well, I'll definitely look for that.
Yes, sir. Thank you.
Judge, this is Mr. Swain. Mr. Swain is before the court in 22 CF 1589 and 15 CF 2207, which is a felony violation of probation. Mr. Swain, we were able to complete depositions on your case last week. I tried to see you last Friday, but we ran out of daylight, so I was not able to see you last Friday. I'm going to ask that we bring Mr. Swain back on docket day, plea or continue, so that I could review the depositions we've already completed. I know Mr. Swain has written me asking for a bond hearing. if that's what Mr. Swain desires, would the court allow me to set that on docket day?
Yes, sir. Mr. Swain, I'll see you a week from tomorrow at 1:30. And if your attorney files a motion hearing for bond, then I'll hear it then. Okay?
Yes, sir.
Thank you, sir. No, Mr. Smith.
This is Alexander Smith before the court in 2 case numbers. In speaking with Mr. Smith at the jail last week, I believe that we're close in negotiation, so I don't want to move this all the way to March. I do ask for this to come back on docket day. My intention is that we will likely be able to get this resolved with a disposition on docket day.
Okay. Mr. Smith, I'll see you a week from tomorrow.
You have a great day, Your Honor.
Thank you, sir. You too.
Next.
You're Mr. Sesson?
Yes.
Thank you, sir.
Judge, similar situation. We added one of his cases onto the docket last time we were in court, and trying to get up to speed and get everything together. I'd like to come back on docket day. I simply haven't had time to discuss it fully with the state. If we could come back, clear, continue on docket day like we talked about, Mr. Sisson, and that's the 17th, which would be an in-person court date here with Judge Brown.
Mr. Sisson, I'll see you a week from tomorrow.
Thank you.
Thank you.
Your Honor, this is Derek Lockhart. He's got a couple of cases before the court. Derek, I'd proposed to the state the 48-month offer that we had talked about last week. They're still reviewing that offer. I would like to leave this on for plea or continue for next Tuesday. We should have an answer by then, and I'll come up to the jail once I get that answer and talk to you. But I have made that offer for you.
Okay, you talking about the terminus?
48 months concurrent and coterminous. Yes, sir.
Mr. Lockhart, I'll see you next Tuesday.
Oh, yes, sir.
Thank you, sir.
Your Honor, this is Kevon Paris, 22 CF 2196. I believe Mr. Paris is going to be one of the depositions that I have scheduled in February with Mr. Gomez. They have not taken place yet. They're not scheduled to take place before next week. I would ask the court to continue this one more cycle. Hopefully we can get this resolved next cycle.
Okay. Mr. Paris, I'll see you no later than March 13th. Thank you. Yes, sir.
Thomas?
Judge, this is Mr. Peyton Thomas. Mr. Thomas is here in 22 CF 471, 22 CF 543, and 22 CF 410. Mr. Thomas, I tried to see you last Friday, but I ran out of time before count started. So at this point, we are still waiting on the information that we were seeking from Emerald Grand, and I have not been able to get an update from my investigator. I know that she was working on that for Mr. Thomas. Mr. Thomas, I believe that that's likely going to necessitate another round of depositions or probably a need for a continuance until March 13th, unless you want to come to court on the 17th, which is next Tuesday, and we can see what status is then, but it's likely going to be the same. I need to get you an update from my investigator. That means I need to get an update from her as well. So, Mr. Thomas, in hearing that, did you hear what I said? Do you want to come to court on the 17th, which is next Tuesday, or do you want to continue the case until March 13th to try to...
17th to see the status, and then the 13th.
That's fine, Judge. If we could bring him in person on the 17th, that way I can get him an update of exactly where we're at with it.
Okay. Mr. Thomas, I'll see you a week from tomorrow.
Yes, sir.
Thank you, sir.
Morrison?
Your Honor, I represent Charles Morrison. The state has a signed plea agreement in their possession if Gomez remembers.
Yes, I do. I'm just trying to...
Your Your Honor, in reviewing the copy that I've got of the plea agreement, I just realized that the case number on the very top right is correct, but then in the body of the agreement, right under plea and sentencing, paragraph 1, it's got 12 CF, and it should be 22 CF.
Okay, thank you.
May I approach, Your Honor?
Yes, sir, thank you. Thank you, sir. Mr. Morrison, if you'll raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. You can put your hand down. Mr. Morrison, so I was handed a plea agreement that states that you would be adjudicated guilty and you'd have to pay court costs within 180 days. Let me make sure. You'd be sentenced to credit for time served. You have to pay $615 in court costs within 180 days and the $150 public assistance fee within 180 days. Is that what you wish to enter that plea?
Yes, sir.
Do you understand that you're waiving your right to a trial by jury?
Yes, sir.
Did you read this written plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
Mr. Morrison, I do accept your plea. You're adjudicated guilty. You're sentenced to credit for time served. You need to pay the court costs and the legal assistance fees within 180 days from today, or they will go to a civil judgment. Okay?
Yes, sir.
Thank you, sir. You have a score sheet? Thank you. Thank you.
Ready?
So Mr. Dillon, after job radar, 22 CF 44, 19 CF 49, 19 CF 2024, and 20 CF 1429. We have the position set for January 30th. After continuance.
Okay, Ms. Studley, it's hard to hear you.
Yes, sir.
You said there's deposition set for when?
January 30th.
Okay, and so you're seeking what?
Continuance.
Okay, any objection from the state?
No objection.
So I'll see you back here no later than March 13th, okay? Thank you, sir.
Thank you.
That's all I have.
Thank you, Ms. Studley.
Right.
Judge, this is Mr. Wendell Wright.
Thank you.
Mr. Wright is here in a number of different cases, and 21 CF 1776, 20 CF 3187, 21 CF 1772, and 20 CF 2804. The last time we saw the court, we were actually in a trial posture, but we had to continue the case because we were seeking additional time to investigate a witness in the primary case that we figured out that we were going to trial on first. And then we'd also discussed with the court that there was a need for a mental health evaluation linked to mitigation. Given the posture of where we're at with the schedule, we've been unable to do that, to get it ready to go to trial this time around. And I've discussed that with Mr. Wright in full at the jail. I'm going to request a continuance until the March date, given that mental health evaluation would be the last thing we reasonably need to do before applying pressure or setting the case for trial. But I will defer to the court, given the age of the case.
Okay. Mr. Wright, do you agree to the continuance?
Yes, sir, Your Honor, I do.
You understand what Mr. McKinney's doing on your case to move it forward?
Yes, sir, I do, Your Honor. He explained it to me.
Good. Mr. Wright, based on that, your case is continued until March 13th, but I am stating trial next time, meaning that it will go to trial at the end of March, okay?
Yes, sir, Your Honor.
Thank you, sir.
Have a good day.
You too.
Watson? Yes, sir.
Judge, this is Bruce Watson. For Mr. Watson's benefit, we've been trying to fill in some deposition time that I had on the 31st of this month to fill in some extra witnesses for Florida Highway Patrol. We were able to get several of those witnesses added to the January 31st date to advance that instead of waiting for a later deposition date. But there is going to be the need for a second round or a third round of depositions out of Pensacola for Florida Highway Patrol and medical examiner. So, Mr. Watson, we are in a position that would need to request a continuance until March 13th. However, I'm steadily trying to get all the depositions completed as quickly as I can.
Mr. Watson, do you agree to the continuance?
Yes, sir, I do.
Okay. Mr. Watson, I will see you on March 13th. However, if Mr. McKinney sets a hearing before that date, I'll see you then.
All right, thank you, Your Honor.
Thank you, sir.
Your Honor, this is Darren Patton. I would like to leave Mr. Patton on for plea or continue next week. We do have an offer from the state for some probation, some county jail. My main concern with Mr. Patton right now is the adjudication status. It's a fleeing case, which normally requires an adjudication. However, he would be eligible for youthful offender sentencing. And I know it's been a long time since I read the case, but I know there's a case that says withholds can happen if the sentence is under a YO sentence. I need to talk to Mr. Gomez about if the state's willing to consider that. But I don't want to just kick this 2 months down the road, especially given the fact he's in custody. Right. So I would like to leave him on for plea or continue next week.
Good. Mr. Patton, I'll see you a week from tomorrow, okay? Thank you, sir.
Your Honor, this is Paul Martinez. We have a deposition in 22 CF 872 that is scheduled to take place next month, or I think it's next month. It might be later this month. It's not any time between now and next Tuesday. Mr. Martinez does have a 5-year suspended sentence in 20 CF 1961. The state has informed me that they will be seeking that suspended sentence. I would, given the fact we have this deposition outstanding, ask to continue this to March. However, once this deposition takes place, I expect the cases will be ready to be resolved, one way or the other.
Mr. Martinez, I'll see you no later than March 13th. Thank you, sir. Thank you, sir.
Next.
Hello, Mr. Latson.
Good afternoon.
Good afternoon.
Good afternoon, Your Honor. I'm Marty Neves. I represent Mr. Latson. We had previously had depositions scheduled for December 22nd, but a conflict arose on my schedule, so we had to cancel. We had been emailing back and forth with Ms. Sharpless's legal assistant, and we're trying to arrive at new dates, so the matter has to be continued.
Mr. Latson, I'll see you no later than March 13th, but if Mr. Nopes schedules a motion before that, I'll see you then.
Thank you, Your Honor.
Thank you, sir.
Election. Yes, sir.
Hello, Mr. Blacksher.
How's it going on?
Doing well, thank you. Who represents Mr. Blacksher?
Judge, I think Mr. Blackshear's case was continued this morning, and
Yes,
I
ma'am.
don't remember whose attorney it was.
That was James Heath.
Okay. Mr. Blacksher, I'm sorry, Mr. Heath appeared this morning and asked for your case to be continued. He said he had brought you up to speed on that and that you agreed to it. So I'll see you no later than March 13th. Okay?
Okay,
thank you, sir.
Your Honor, before the court is Kevin McLaren, and his case numbers are 22 CF 2256 and 2634. Your Honor, I think we're pretty close to a resolution in this case. We can bring Mr. McLaren back on Thursday if the court prefers, or we can wait until Tuesday. He's not going to be getting out of custody before Tuesday, so if we want to just leave him on for docket day, plea or continue.
Okay, let's do that. Mr. McLaren, I'll see you a week from tomorrow, okay?
Yes, sir.
Thank you, sir.
I'll give you right there. Next. Yes,
This looks like Kevin Wright.
Yes.
Mr. Wright is here in 22 CF 1838. We completed the depositions last week. We discussed it at the jail. Mr. Wright wishes for me to file a motion for bond. Is that still what you want me to do, Mr. Wright?
Yes, please.
And Judge, we're actively trying to resolve this case. Like I stated, we are complete with the depositions. There's no further additional discovery work we'd like to do, but we would like to engage with the state in plea negotiations, which is what we're currently doing. So I'd like for Mr. Wright to come back on docket day, plea or continue, and I would like the opportunity to file a bond motion for Mr. Wright.
Okay, if there's nothing else that needs to be done to prepare for trial, we could still have the bond hearing a week from tomorrow, but why wouldn't we schedule it for plea or trial?
I know if we're able to resolve the matter, then I know that the state wouldn't have to send out subpoenas to then ultimately cancel them. I know that, but I'll defer to the court.
To the state?
It doesn't matter to the state judge. We can set it with subs, that's fine.
Yes, ma'am. So, Mr. Wright, I'll see you a week from tomorrow at 1:30 on your motion for bond, and I'm setting it for a plea or trial. If the state has made any offers to you, traditionally they withdraw those. If it's not accepted on docket day, which is a week from tomorrow, and then we'll be looking at going to trial at the end of the end of January. So I'll see you a week from tomorrow. Talk to Mr. McKinney about the offer from the state. You decide whether you think it's in your best interest to accept it or not. If you say, nope, I want to go to trial, then that's what we do.
Okay, thank you. I appreciate it.
Mr. Wright, while you're here, before you walk away, I mean, we have been in plea negotiations, and the offer is better than the last time we spoke last week, but that's something that we need to discuss before we come back to court next week. I think it's next week.
Okay. All right, thank you.
Thank you. Hello, Mr. Triplett.
Yeah, no, sir.
Mr. Triplett has two cases before Your Honor, 22 CF 2603 and 22 CF 2986. We've received discovery in one of the cases, but not both of the cases. I don't believe that we're going to have all that in time realistically to get that to Mr. Triplett and to come to a resolution. Mr. Triplett, I'm going to request a continuance until March 13th for both of these cases so that we get all the discovery with the intention. And I see your brow furrowing that's a long time from now. Keep in mind that you know that as soon as I get all the discovery, we'll sit down, we'll go through it, and if we reach an agreement, then we can get back before the judge for a plea agreement if we have a resolution.
Right, is there a plea agreement on the table right now? I mean...
There's not. I don't even have all of the discovery, Mr. Triplett, which is why I'm having to ask for a continuance.
To the state, is there, hold on, Mr. Triplett. To the state, is there any offer to Mr. Triplett at this point? Good question, Mr. Triplett. It's always good to know what's out there.
Mr. McKinney, he accepted felony plea date in the 2986 case on Thursday, so when you're there.
Okay.
And Mr. Triplett, too?
Is it one-time information? Yes. We will enter a plea of not guilty in 22 CF 2986, the one-count information, waive its formal reading.
Okay.
Mr. Triplett, there is an offer for 12-1 followed by 2 years probation, but that doesn't include the second case number, which I don't have discovery on.
Right, no, sir, yeah. The discrepancy that I really have right now, sir, is that I have a hold for Walton County, and I don't even score out to prison, so I don't understand that. But if there's any other offer, maybe I could, I'd take 90 days right now and go to Walton. I still have a bigger charge over there to take care of. So if we can work that in, stay out, let me guilty right now in 90 days.
Mr. Triplett, it's the court either accepts or doesn't accept a plea offer if there's a negotiated plea between you and the state. Right now, as you were making those statements, the assistant state attorney was shaking her head no. If that's not the case, then you can enter a plea straight up, which would mean there would be no agreement with the state. You could be sentenced up to the maximum. I have no idea what I'd sentence you to because I don't have all the information. Or you can go to trial. So those are the options at this point. But at this point, I don't have a negotiated plea, so I can't say what I'd sentence you to.
And Mr. Triplett, keep in mind that only one of your cases is set for the docket today. The other one that we just entered a plea of not guilty to. So as soon as I get the discovery for everything, then I'll come see you and we'll see if we can resolve it. But I don't think that that's going to happen today.
I don't have a court date on the 12th as well. 3 days.
You would have if I just entered a plea of not guilty. That's the only thing that would have happened on the 12th.
Okay, so
I'm trying to put
taken care of today, this one?
I'm trying to put everything together on the March 13th date as a backstop. That way, if we don't have an agreement, that's where we end up going to.
All right. Thank you, sir.
So, Mr. Triplett, I'll see you no later than March 13th on both of your cases. If your attorney wants to set a hearing before that date, then I'll certainly see you then.
I appreciate that, sir.
Thank you.
Please continue, Mr. McGinn.
Will do.
Yes.
Adam Stevens?
Judge,
Yes, sir.
Judge, if we could bring Mr. Stevens back on docket day, plea or continue.
Okay, Mr. Stevens, I'll see you a week from tomorrow, okay?
Okay.
Thank you.
Thank you. Next.
Your Honor, this is Tommy Lucas. He has got 3 cases. The newest case is 22 CF 2788. On that particular case, Your Honor, I don't have discovery yet. So I would ask the court to continue this. And we do have an affidavit from the alleged victim in that case that has been sent over to the state. So, Tommy, I'm doing this as fast as I can. I'm going to have to ask for a 1-cycle continuance, but I'll see if we can get everything resolved here in the next couple of weeks, okay?
Yes, sir.
Mr. Lucas, I'll see you no later than March 13th.
Yes, sir.
Thank you.
Next.
Your Honor, I believe this is Michael Chiricciello. We were appointed to Mr. Chiricciello's case in middle of December. RCC had him prior to that. I talked with my supervisor today in court. The conflict still exists. I'll orally move to withdraw from Mr. Chiricciello's case, and based on representing a co-defendant in the case, Ernest McFarland.
That motion to withdraw is granted. Regional conflict counsel is appointed.
Thank you, Your Honor. And Mr. Chiricello was my client prior to his failure to appear. Michael, can you hear me okay?
Yes, ma'am.
Okay, hey, it's Katie. If you want to resolve your case today, the state's offer is to do 60 days county jail with credit for the time you've already been in there, and they won't take any action on the failure to appear, and your case would be resolved. Is that something you want to do?
Yes, ma'am.
And Your Honor, I know that Mr. Chiricello technically hasn't signed this, but I've represented Mr. Chiricello before, and I thought this might be something he'd be interested in. So I did write it up, and I would just like to submit the written terms of the plea to the court just to make sure the fact that the state is taking no action on the failure to appear is in the record. Just in case the jail has any questions, they'll see this.
And the state signed that?
No, the state and I have not signed it because I wasn't sure if Mr. Chiricello was willing to accept it, but I will sign it now and ask Mr. Gomez to do the same.
Okay, and so it would be 60 days in the Okaloosa County Jail with credit for all time served, court costs, $150 public assistance fee, and there'd be a period of time for him to pay that?
Yes, Your Honor, I would just ask the court give him 180 days after his release to pay it.
Okay.
And Your Honor, as well, I'm sorry, I lost my train of thought. All counts are concurrent.
Okay, thank you.
I knew it was important. I just didn't remember what it was. I apologize, Judge.
Mr. Chiricello, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. You can put your hand down. Mr. Chiricello, did you understand the terms of the plea agreement?
I did.
Okay. Do you have any questions for the court or Ms. Jaquin or the state about that?
No, I don't.
Do you understand that you're waiving your right to a trial by jury?
Yes, sir.
I do accept your plea. You're adjudicated guilty. You're sentenced to 60 days in the Okaloosa County Jail. That's with credit for all time served, and that's to run concurrently on each count. So that means at the same time, all monetary assessments mandated by statute or county ordinance are imposed. That's the court costs, $150 public defender's fee or public assistance fee. If you fail to pay those amounts within 180 days from your release from the jail, then they will go to a civil judgment. Thank you, sir.
Thank you.
And Your Honor, that's all I have before the court this afternoon. May I be excused?
Yes, ma'am. Thank you. You're Mr. Claiborne?
Sir.
Mr. Claiborne, you're representing yourself, I believe? You don't have an attorney?
Sir.
Okay. Mr. Claiborne, were you previously offered an attorney and you didn't qualify?
Judge.
Yes, ma'am.
He had an attorney, but he posted a bond, a very significant bond, and so RCC was removed, and he was supposed to be finding a private attorney.
Thank you, ma'am. So, Mr. Claiborne, you're representing yourself, I take it? You don't have an attorney, correct?
Oh, no, sir. I've been trying to find an attorney. I don't have any money, sir.
Okay. So, to the state, are you seeking to go to trial on Mr. Claiborne's case?
Judge, we can set it, it's a murder case, so I think that we need to get an attorney assigned, so.
Okay, so even if he doesn't qualify financially, I'm going to appoint an attorney?
No, Judge. We can set it for trial, but we need to probably find an attorney between now and then.
Mr. Claiborne, I don't think you qualify financially for an attorney, but since you don't have private counsel, the only thing I can do, I can't make anybody do anything other than go to trial. And that's the only way I can see of disposing of your case if the state hasn't offered you something that you wish to accept.
Yes, sir.
So, Mr. Claiborne, I'm setting your case for trial. I'll see you on docket day, which is a week from tomorrow. On January 17th, we'll be looking at going to trial on January 23rd or February 6th. Okay?
Yes, sir.
So, if you're going to hire private counsel, you need to do it sooner than later. Exhaust all the remedies of trying to find private counsel. Okay?
Sir.
Thank you, sir.
Next. Sir. Good afternoon.
Yes, sir. Good afternoon. You're Mr. McGregor?
Yes, sir.
Thank you. Who represents Mr. McGregor? Mr.
Your Honor,
Green?
that's my case.
Okay, good. Mr. Catalanic?
Thank you, Your Honor. Your Honor, on Mr. McGregor's case, we're set here for 22 CF 2810. Your Honor, I was trying to get the case, it's the first pre-trial, I was trying to get the case resolved today. What I would love to do with this case is I would love to leave it set for next week. We may be able to get it resolved by that date. I also have his family in here that are here for your support. Mr. McGregor, what I'd like to do, Your Honor, I'd like to request the court to grant my motion to amend the no contact order to a no violent contact, so his wife, the victim, can see him at the jails, which she is requesting, and I don't have an objection by the state.
To the state, any objection to the no violent contact?
There is no objection, Your Honor, based off of the wishes of the victim.
Okay.
May I approach, Judge?
Yes. So, Mr. McGregor, your motion is granted so you can have no violent contact with the alleged victim, and I will see you a week from today at 9 o'clock. Okay?
Okay. Okay.
Thank you, sir.
Thank you, Judge.
Next.
Thank you, Mr. Catalan.
Thank you, Judge. Judge, this is Mr. Brett Phillips.
Mr. Phillips. I was just going over my notes, Judge. Mr. Phillips needs to come back on docket day, which is a week and a day from today, Mr. Phillips, so that we can have an opportunity to be in the courtroom in person so that we can go through the offer on the record from the state. I'd like to do that, not as a drop dead date, but so that we know exactly where we stand with the state as far as an agreement. That's something I've been working back and forth with Ms. Barickman on.
Okay.
So I'd like to come back on docket day, clear continue.
Mr. Phillips, I'll see you a week from today. A week from tomorrow, I'm sorry, okay?
Sir.
Thank you, sir.
Your Honor, this is Jonathan McNabb. We're going to have to leave Mr. McNabb on for plea or continue next week. I am trying to get the state to agree to dismiss this charge. The facts are that Mr. McNabb was sentenced to 6 years in the Bureau of Prisons with the federal government based on this exact fact pattern. And so and I have talked to his assistant his assistant federal public defender, who has informed me that even if the state insisted on concurrent time, then the state would be picking up the first 3 years of Mr. McNabb's incarceration as opposed to the federal government, because apparently the feds won't come get him until he's done with any state sentence. So I would like to leave Mr. McNabb on for next Tuesday. I'm trying to encourage the state to null process so Mr. McNabb can be transferred to the Bureau of Prisons. I don't have an answer yet, though.
Okay. Mr. McNabb, I'll see you a week from tomorrow. Thank you, sir.
Your Honor, this is William Martinez Gonzalez. I would ask to leave Mr. Gonzalez on plea or continue next week. William, I'll be up at the jail this week to see you. We can either hopefully get this resolved next week with maybe some kind of an agreement or a bond motion, okay?
Okay, sir. Thank you.
So I will see you a week from tomorrow. Mr. Klein, so do you want to schedule it for 1:30?
However the court wants to handle it.
Well,
I haven't read the motion yet, so.
If you're going to file a motion for bond, that'd be a good time to do it.
Okay, I will, if I'm going to do that, I'll do that on Wednesday and get it set.
So 1:30 on Tuesday.
Yes, sir, and I'll make a note of the time.
You're Mr. Hosley?
Yes, sir.
Thank you. Mr. McKinney?
Judge, I represent Mr. Hosley. Mr. Hosley has co-defendants with RCC and also with Mr. Stevens. We've coordinated and set depositions in February, but I'm going to request a continuance in 22 CF 1827 so that we could do the depositions with the co-defendants' attorneys. Additionally, we are waiting on FDLE lab results in this case as well.
Okay. Mr. Hosley, I'll see you no later than March 13th. Thank you, sir.
Mr. Hosley, do you have a question, sir?
Yes, sir. So, my lawyer.
Your attorney is Mr. McKinney. He's at the podium speaking. Yes, sir.
Hey, Mr. McKinney, when I just talk to you and whatever, you say you were going to try to, talk to him about, since I've been here 7 months waiting on the result, you say you were going to talk to him about, get things resolved about the MDLE.
Yes, sir. And if we don't have lab results soon, like we had talked about, given that it's been 6 to 7 months, then we can always seek help from the court, like we had talked about, to try to move that along. So I've talked to the state, and they're going to try to reach out and kick things on their end to try to get it moving. If that doesn't happen, then we can always file a motion with the court to try to make that happen as quickly as possible.
Please?
Yes, sir. I understand.
Mr. Hosley, so what that means is that if your attorney files a motion to compel FDLE to produce those records or those results, then Mr. McKinney can set that for a hearing before March 13th, and I'll have that hearing then, okay?
Thank you, sir.
Thank you, sir. Mr. Lovett, how are you?
All right.
Good. So Mr. Lovett's representing himself. Mr. Lovett, were you previously offered an attorney and you didn't qualify? Okay, so you're going to represent yourself?
Yeah. Well, I ain't got no ad, but I ain't seen me or nothing about it.
Okay, is there an offer to Mr. Levitt?
I'm trying to find the file, Your Honor. Your Honor, I don't seem to have that file in my bucket, so I'm not prepared to give an offer this time.
Okay, so we're going to set it for plea or trial?
No, Your Honor, I think it would be a plea to continue. The state's not ready for trial.
Mr. Levitt, I'll see you back here a week from tomorrow. If you're going to hire a private attorney, you need to do it sooner than later so that they can work on your case. But I'll do my homework and get up to speed, and I'll see you back here a week from tomorrow, okay?
All right.
Thank you, sir.
Yes. Thanks.
Mr. Noakes, who represents Mr. Spence? Mr. Noakes, do you represent? Okay, please. You do or you do not?
Stephen Nettles.
Mr. Nettles does. Okay, Mr. Nettles was here this morning.
Judge, Mr. Nettles, I believe, continued the case. It was the first time I've with him as the attorney of record.
Okay. Mr. Spence, I believe Mr. Nettles said that he had spoken with you about a continuance. Did you agree to the continuance?
I suppose so.
Well, do you understand what Mr. Nettles is doing on your case to move it forward? And that, do you believe he needs additional time? Or do you want to come back before the court a week from tomorrow, and I'll make sure that you and Mr. Nettles are together at that point?
That's fine. Whatever needs to be done.
Well, it's up to you. If you want to be here a week from tomorrow, or if you want to come back on March 13th, it's up to you.
I'd love to be there a week for tomorrow.
Okay.
Or just whatever Mr. Nettles recommend. I'm unable to postpone because of an FTA I had over 20 years ago.
Okay, hold on. I don't want you to say anything that may hurt your case, so I'm going to set you for a plea continue. So I'll see you a week from tomorrow, and the clerk will notify Mr. Nettles that it's not a continuance, that it's plea or continue, okay? So I'll see you next week.
Okay, thank you.
Thank you. You're Mr. Weaver?
Yes, sir.
Thank you. Mr. McKinney?
Judge, I represent Mr. Weaver. We got notification that he may qualify for an inpatient over in Pensacola. Mr. Weaver was returned back to this docket after being evaluated for mental health court, observing mental health court, but then being determined that he wasn't an appropriate fit for mental health court.
Okay.
The short answer is we're trying to put hands on it to see if we can resolve the matter. He does score state prison, but we are trying to see what other angles we can take at this. So I'd like to come back on docket day, plea or continue, because I don't want to continue it all the way to March.
Yes.
If we can try to put hands on it to get it resolved.
Okay. And I will send you that case that I referenced.
Yes, sir.
That may be, in that case, it talks about misdemeanors. So I'm not sure if it applies to felonies or not.
Yes, sir.
It wasn't the state's opposition that kept him out of mental health court.
It was mental health court that decided mental health court wasn't a good idea. Is that the best way to say it?
Right.
Okay. And I'm not sure. Mr. Weaver, what we're talking about is in April there was an appellate case that talked about being accepted into specialty courts such as mental health court. So I was just making the attorneys aware of that, where we can all be on the same page about that. So that's what we were speaking of. I'll see you back here a week from tomorrow, okay?
Sure.
Thank you.
To be clear, he scores over 60 points, so he's not going to get down departure just for drug treatment.
Understand.
Unless the state agrees to it.
Understand. Mr. Mr. McKinney?
Judge, this is Mr. Trombley. As we talk about mental health court, I've tried mightily to talk Mr. Trombley out of not doing mental health court, but he is insistent that he wants to do that. And I'm not making light of the situation, but Mr. Trombley is going to be going into mental health court for a violation of probation and a new felony charge. So he understands the seriousness of his charges. So I believe that this is going to be coming off of Your Honor's docket and going on to the mental health court docket. We probably just need a control date to make sure that that happens.
Okay. So Mr. Trombley, just good luck in mental health court. I wish you the best there. They have a lot of tools that I don't have. So I wish you success there. Just for our docket, I'm going to continue it until March 13th. But once mental health court takes over your cases, then you'll drop off my docket. Thank you, sir.
Yes, sir.
So you don't want to add these to the mental health court docket?
They should already be going that way.
Because I can add them to the next mental health court.
Sure. I've been told that we're all green all across the board, but that's something that I know that Ms. Adams usually has control on that docket when they add it on.
Thank you. Yes, sir.
Judge, this is Mr. Michael Thompson before the court. Mr. Michael Thompson's here in 3 case numbers, 22 CF 1332, 21 CF 2624, and 22 CF 27. I'd like to come back on docket day. I know Mr. Thompson is eager to try to resolve this matter, but I'd like to try to do whatever I can without just continuing this to March to complete depositions. So I want him to come back on docket day.
Good. Mr. Thompson, I'll see you next week on Tuesday.
Yes, sir.
Thank you.
Perkins?
Hello, Mr. Perkins.
Hello, Your Honor.
Your Honor, this is Sean Perkins. Hey, Sean, I have proposed what we talked about last time we met. The state has countered with a 36-month Department of Corrections sentence. I would like to talk to you before next Tuesday and figure out what you want to do with this. I would like to say, Judge, if we could put this on plea or continue for the 17th. Unless Mr. Perkins, you could, I know way back before I got reappointed, you were going to come in and just take an even higher number. I don't know if you wanted to take the 36 months, but I can't get them to go lower than that.
You said you can or can't?
Cannot.
Cannot.
And Mr. Perkins, if I may, Mr. Perkins, ASA Verickman, I know we had some discussion as well between when Mr. Kynes was appointed and when he wasn't. We had discussed the 36 months waiving prior credit, but that the credit would start from November 21st, 2022. You and I had that discussion at the podium. Do you recall that?
Yes, ma'am.
Okay, so that would be the state's offer today.
And you'll hold that offer open through next Tuesday?
Yes.
Mr. Perkins, because it's a DOC sentence, I want you physically here. If you're going to enter that plea, I want you to read through the written plea agreement. So I'll see you a week from tomorrow, okay?
And Sean, I'll be up at the jail later this week. It's probably going to be Wednesday or Friday. I've got court here on Thursday. But I'm going to be up at the jail at least twice this week, and I'll talk to you then, too, also.
Yes, sir, Your Honor. Yes, sir, Mr. Klein.
Thank you, sir.
Thank you. Yes, sir. Next.
Mr. Phillips?
We filed a waiver of appearance for Spence.
Okay, thank you. Mr. Wooden?
Yes.
This is Mr. Williams, court in 19 CF 2156. Judge, we're trying to resolve the matter. Mr. Wooden is back on the docket after coming back from Florida State Hospital. This was originally an arrest date in 2019. So we're trying to get this matter resolved in a way for Mr. Wooden that takes that into consideration. So I'd like to come back on docket day, plea or continue, so we can see what the offer might be from the state. I know that they needed time to reach out to the victim.
Okay. Mr. Wooden, I'll see you back here next week on Tuesday.
Okay. Yes,
Thank you, sir.
Thank you. Next.
Mr. McKinney?
This is Mr. Towery. Mr. Towery is before the court. And ultimately, we'd like to come back on docket day. And I know that Ms. Brickman is not available for a bond hearing on the 12th, so I'd ask to be able to have a bond hearing on on the 17th. If we could set this at 1:30
Okay.
for 22 CF 1766. I've discussed that with Mr. Towery. Ultimately, we're going to be asking for a continuance to do depositions at the end of result of that, but I'd like it to come back on docket day primarily for the bond hearing.
Okay, so Mr. Towery, I'll see you at 1:30 a week from tomorrow on your bond hearing, okay?
Mr. Towery, your father was here this morning and here in support of you. He's probably going to be here at the bond hearing, but he wanted me to let you know.
Okay, thank you.
Thank you, sir.
Yes, sir. Sir.
Judge,
Good evening.
this is Mr. Eric Smithwick before the court. Mr. Smithwick, I'm still waiting on a response from Mr. Sawicki. I told you how uncharacteristic that is of Mr. Sawicki and the expert, but that is the position that we're in. We still need that information before we can reasonably go forward. So I'm going to have to request a continuance today. Obviously, if we reach any type of resolution, we could add this back on to an earlier court date, but we really need to hear from Mr. Sawicki in his view of digital evidence in this case before we raise our hand and say ready for trial.
Okay.
Yes, sir.
Mr. Smithwick, I'll see you no later than March 13th.
Thank you.
sir.
Next.
Judge, this is Herbert Schmidt before the court in 22 CF 416. Mr. Schmidt, the last time that we did depositions, we did get additional information from FDLE related to the cell phone download, and we have a new witness for the FDLE related to the cell phone download that we've talked about. That's going to require me to do a deposition of that FDLE analyst that actually looked at the phone and did the cell phone download. So that's going to put us in a position that I do need to request a continuance because we were trying to make that deposition happen as quickly as possible by a phone.
So you're seeking a continuance?
Yes, sir. Mr. Schmidt, did you have any questions? Can you hear me okay?
Yes.
Okay. Our options are continue this until the March 13th date, and I do the phone deposition with the FDLE analyst that did the cell phone download, or we come back to court in person on the 17th if you want to talk to me about that more reasonably than the setting we're having right now. But I would be seeking a continuance on the 17th regardless because we need to complete the deposition. Does that make sense?
Mr. Schmidt, do you want to come in next week, a week from tomorrow, and see your attorney? Or do you want me to continue your case until March 13th and your attorney will come see you in the jail?
Continue.
Okay?
To March.
Okay,
Yes, sir.
then I'll see you no later than March 13th.
As soon as we get that done, I'll come up and review that with you.
Gotcha.
Judge, this is Mr. James Salter before the court in 21 CF 3238. Judge, we did, at the end of the year, we did the deposition with the Williams Rule witness. The state has filed a Williams Rule notice. We filed our objection. The state's notice of intent to use Williams Rule evidence. That was filed after discussions with the state that they were no longer going to or file any additional witnesses. So that was filed last week. That's going to necessitate a hearing before Your Honor related to the Williams Rule evidence because Mr. Salter is in the position that he wishes to go to jury trial, but he also objects to the state using any of the Williams Rule evidence related to a prior incident at that jury trial.
Yes, sir.
So I know that Mr. Salter wants to get to trial as quickly as possible. The route that gets us there is going to have to go through a Williams Rule hearing that we're asking the court to schedule on the earliest available date. I know Ms. Brickman has some scheduling conflicts, so we'd like to look at the schedule and see when we can get this on the earliest available date.
Madam Clerk, the afternoon of January 19th, is there anything set then? Ms. Brickman, are you available then?
Your Honor, the issue with that is we have a witness we're going to have to coordinate, and
basically transport down here, with our victim advocate. So we would ask for a little more notice.
If we were going to be trying to get to a trial, then the 19th would be on the afternoon of jury trial review. Is that
Correct.
accurate?
Yes, sir.
So I don't know how realistic that would be.
I agree. I don't think trial this cycle is going to happen.
And I know Mr. Salter wishes to get the trial as quickly as possible, but at the same time, we need to get through that hearing. And I'd like to set a hard date that if we're going to the next cycle or going to the next month, that we are priority to get to a trial on that cycle.
Okay. Why don't we schedule it for February 16th at 2:30 is the motion on the Williams rule. And then we'll be looking at going to trial on March 27th.
In Your Honor, the 16th, I'm unavailable. Can we do the 13th, the 20th, or the 23rd miscellaneous days?
And again, I think I've got the 13th stricken.
Okay.
We may have an all day. So February 20th then.
Okay.
February 20th?
At 1:30.
Mr. Salter, so you heard that discussion in the courtroom related to the Williams rule evidence. That means that we would have our hearing where you would be here in person with me for the Williams rule hearing, and the court would be making a decision on that on the 20th of February, and then we would be able to prepare for trial based on the court's ruling.
And we'll be going to trial in March.
Okay?
Okay. Thank you, sir.
Thank you, Judge.
Next.
Oh, Mr. Russell.
Judge, Mr. Russell is before the court in 22 CF 2232. He's charged with failing to register. He also has a case going in Escambia County that I'm trying to get up to speed on a little bit to see how that affects him. It's also for failure to register. He scores almost nearly the maximum, which I'm going to request a continuance today unless we'd like to leave this on for docket day. I think that depositions would be warranted, and we have not had the opportunity to do that yet.
Okay. Mr. Russell, I'll see you no later than March 13th.
Yes, sir.
Thank you.
Next. Rodney. Yes.
This is
Sir, are you going to want to see the maxes, is there an action, or can we just communicate that these have been continued, or we got to start getting them ready and it'll be a time-consuming process?
I'm not aware of anyone saying that we were continuing those. Is the state, you aware of any continuances on the maxes? Or who represents him? There's private counsel, Mr. Noakes.
Judge, I was appointed at the middle of December, but I really didn't look at any of it until the end of the first of the year, to Mr. Miles. And I was going to continue that today because I've just been appointed.
Have you spoken with Mr. Miles about that?
Judge, I have not. I went to the jail the other day to see him, and there was a problem with seeing Max. So.
Okay. Then we'll need to see Mr. Miles today. Jail?
That's fine, Judge.
Okay. Then who represents Nathaniel Riggs?
Your Honor, I believe that case was continued last week. It's a Benjamin Buck, if I recall correctly, that filed a motion at the end of last week.
So it looks like the order was filed into one of the cases, but not the other.
Okay. And who represents Mr. Riggs?
It is Benjamin Buck, Your Honor.
Okay. So the second case for Mr. Riggs is also continued. Okay. So we don't need to see Mr. Riggs jailed. Then what about Jonathan Yates? Who represents him?
He's in another institution. What about, we got Wooden, the Desmond Wooden?
Judge, I'm standing in for Mr. Gates. We would need to see Mr. Wooden.
Okay.
And Ishan Scott.
Okay, so Wooden was continued?
No.
Yates was continued, okay.
Yeah.
Scott, we'll need to see Scott?
Correct.
PD? Okay. And then what about Morris?
Your Honor, Mr. Morris,
There are other institutions that are not available.
he is in the Escambia County Jail. Your Honor, he is represented by Jason Cobb.
And was a continuance filed on that?
I do not believe so, Your Honor.
No? Okay, so Mr. Cobb represents Morris. Morris isn't here.
Your Honor, if I may?
Yes, sir.
Mr. Jason Cobb sent me over for Mr. Morris, and
Good.
he is seeking a 2-month continuance for discovery reasons.
Okay. Does Mr. Morris know about that? Is he consent to it?
Judge, I'm not aware of that.
And so the state doesn't object. I, of course, don't know if that's been communicated to Mr.
I'm going
Morris.
to do plea continue on Morris because I need to hear that Mr. Morris knows what's going on and he
Yes, sir.
consents to it.
I'll
So plea continue on Morris.
Your Honor, with that, that does conclude my business, if I may be excused.
Yes, sir. Thank
I
you,
appreciate
sir.
that. Thank you, Your Honor.
Okay, then what about Justin Price?
Your Honor, Jail, can you tell me where Mr. Price is? I don't know where he is. He's not in any of the Florida County jails right now. I would ask the court to continue that one cycle. I don't know why he's at the Florida State Hospital. This was a grant, it's a simple grand theft auto case, and when I saw he was back in custody in Max, but in another institution, I was like, well, that's kind of weird.
Do we want to continue it as far as the docket? What I'd suggest is you talk to Mr. Price and set it for a hearing before that date. Because of his logistics, I'd try to get him here sometime before March 13th, if you could, just for a miscellaneous.
I don't even know how he's at the Florida State Hospital because competency was never brought up in this case. So I don't know if he's there for another reason. But
Okay, so Mr. Price's case is continued. So the only maxes are Miles and Scott and Wooden, correct? That we'll
Yes,
meet
sir.
this afternoon? Okay, thank you, Joe. Okay.
Yes, sir.
You're
Yes.
Mr. Rogers?
Yes, Your Honor.
Good, thanks, Mr. Rogers.
I represent Mr. Rogers, and we're trying to get this worked out. And I believe, in speaking to Ms. Rickman, that to come back on docket day, if they continue, that we'll be in a better position to try to resolve this next Tuesday if we're able to do all the homework we need to.
Okay, Mr. Rogers, I'll see you a week from tomorrow, okay?
Is that Eddie Rogers or Josh?
This is Eddie Rogers.
Thank you, Mr. Rogers.
Thank you, Your Honor. Next, Mr. Beck.
Your Honor, this is Calvin McKinney. We do have an agreement with the state to resolve this. I don't have a written plea agreement. This would be a plea to a lesser included offense. Count 1 would be a plea. Calvin, you still good with this?
Yes, sir.
Okay. I didn't want to waste a ton of time and have to be like, no, I changed my mind. So count 1, Your Honor, Mr. McKinney's going to enter a no contest plea to the lesser included offense of felony battery. The agreed upon disposition for that particular count would be 5 years of probation. As a condition of probation, he would have to do a sex offender evaluation and any recommended follow-up treatment. He will have no unsupervised contact with minors. He will have no contact with the victim in this case with the initials MPK. Calvin, I did talk to the state, and regarding your sister's kids, you're just going to have to talk to probation, and if your sister requests the contact be modified, then you can request it through probation, okay? The state's not going to agree to this up front just because they can't right now.
Mr. Jones, you guys can help to clear that up.
That's fine. Yeah, that's fine. Hey, Calvin, if there's an issue with it, call my office when you get out, okay? And I'll work with you on doing what we can to modify that if we have to. The state's just not in the position right now to be able to do that. So until further notice, it's no unsupervised contact with any minor. Definitely no contact with MPK. Counts 2 and 3, Your Honor, are going to be pleas to the lesser included offense of contributing to the delinquency of a minor. Madam Clerk, that statute number would be 827.04, subsection 1B. The sentence on counts 2 and 3 would be time served. There would be a withhold on count 1. Ms. Berrigan, did I miss anything?
There'd be a subsidies to Allen.
Oh, Calvin, there's a substance abuse evaluation and any recommended follow-up treatment also.
Random urinalysis.
And-
Do you have a score sheet, Mr. Klein?
I don't think I have the score sheet.
The adjudication on counts 2 and 3.
Those are misdemeanors, Your Honor, they'd be adjudicated.
Yes.
Thank you. Mr. McKinney, if you'll please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, Your Honor.
Thank you, sir. You can put your hand down. Mr. McKinney, so did you understand everything that Mr. Klein stated today on the record?
Yes, sir.
Do you understand that you'd be waiving your right to a trial by jury if I accept your plea?
Yes, sir.
Do you have any questions for the court or your attorney or the state about the plea or the sentence?
No, sir.
Mr. McKinney, do you understand what the sex offender evaluation and any recommended treatment, if they do any treatment, do you understand what that may entail?
Yes, sir.
Mr. McKinney, I do accept your plea. Adjudication is withheld. In count 1, you're adjudicated guilty. In counts 2 and 3, you're sentenced to, all of them are lesser included offenses. Counts 2 and 3, you're sentenced to time served. In count 1, so withhold of adjudication, you're sentenced to 5 years probation. You'll need to submit to a sex offender evaluation within 30 days from today. Begin any treatment if it's recommended within 60 days from today. Have no unsupervised contact with any minors. You'll have no contact with the victim, MPK. You'll need to submit to a substance abuse evaluation within 30 days from today. Begin any treatment if it's recommended within 60 days from today. Submit to random urinalysis. All monetary assessments mandated by statute or a county ordinance are imposed. That's the court cost. You'll need to pay the $150 public defender's fee and the $40 per month cost of supervision. You do have 30 days to appeal this judgment and sentence. If you wish to appeal, it must be in writing. If you cannot afford an attorney to represent you for that appeal, one may be appointed for you. Do you understand your appellate rights?
Yes, sir, I do.
Thank you, sir.
Okay, that's it. Judge Brown, inmate Walton is wanting to refuse.
Okay, Wooden?
You want to authorize force to bring him here, or?
Judge, I'm standing in for Mr. Gates for Mr. Wooden, who is a max. I know that they are doing depositions, some of which are out of state. So that Mr. Gates' intention was to request a continuance of the matter. I don't believe the state was in a position to object.
Are you waiving Mr. Wooden's appearance today?
Technically, I think he's waiving his appearance, but
well, I mean, I can make them bring Mr. Wooden before the court.
I don't think that that's going to gain us anything, Judge. So I would waive his appearance for today. But I'll ask Mr. Gates to go speak with Mr. Wooden to figure out if there's any issues that need the court's attention.
Okay. I'm going to continue Mr. Wooden's case until March 13th.
Next.
Thank you.
Your Honor, this is Brian McKinney. I would like to leave Mr. McKinney on for plea or continue next Tuesday. We have proposed a possible resolution to these two cases. I can tell the court, and also Mr. Gomez, this morning in court, Mr. McKinney's girlfriend gave me a series of letters. I clearly have not had a chance to give them to Mr. Gomez yet, but I'm trying to get these cases resolved short of an actual hearing. So I would like to leave Mr. McKinney on plea or continue for next Tuesday.
Okay. Mr. McKinney, I'll see you a week from tomorrow, okay?
Yes, sir, Your Honor.
Thank you, sir.
Okay, night, sir.
You too.
Next.
Judge, this is Mr. Jose Herrera Cabrera. He's here in two case numbers, 21 CF1101 and 21 CF1365. Judge, I'd like to come back on docket day for the purpose of having a bond hearing. He has family in the courtroom who's provided me with information that they want heard at the bond hearing. I've indicated that we would do so. Procedurally, I do believe that we're going to be requesting a continuance, but at the bond hearing, I would like to make record of the state's offer. I have reviewed that with Mr. Herrera Cabrera at the jail, but I'd like to make record of it when we come back on next Tuesday.
So plea continue, and the bond hearing will be at 1:30.
Correct.
On January 17th, Tuesday.
Yes, sir.
Thank you. Thank you, sir. I'll see you then.
Thank you, Your Honor. Flores?
Hello, Mr. Florence.
Your Honor, this is Zachary Florence. I can tell the court that Ms. Barrickman and myself have had numerous discussions on resolving this case. On behalf of Mr. Florence, I have proposed to the state a 15-year prison sentence. The state has rejected that. I'll let Ms. Barrickman fill in the court what the state's current offer is. I believe we're going to be asking for one last continuance, but I do expect this will probably be a plea to the bench. And if that's going to be what's going to happen, then I'll probably move them up into a date in February, Your Honor, so we can get that process started.
Okay. Yes, ma'am. Ms. Barrick.
Mr. Florence is currently charged with sexual battery of a child under 12 in 21 CF 2038. He's also charged with 15 counts of possession of child pornography and 15 counts of promotion of sexual performance. As charged on the sexual battery, of course, that's a life in prison sentence. State's plea offer would be to plea as charged in 21 CF 2088 and plea to an attempted sexual battery in 21 CF 2038 to 40 years Department of Corrections, followed by a lifetime. 40 years in the Department of Corrections, followed by a lifetime of supervision.
Okay. So, does the state intend to withdraw that offer next week?
Not next week, but given the magnitude of the case, Mr. Kleinstaff thought it would be prudent to address it this cycle before we announce next cycle.
So, Mr. Florence, what I hear is that your attorney wants to continue the trial until March 16th? No, March 13th? Then I'm putting trial next time, which would mean that we'd go to trial the end of March, beginning of April. If you decide that you want to enter a plea, whether it's straight up with no agreement with the state, then Mr. Kleins can set that hearing before March 13th. Okay?
Okay. And just so the record is also clear, Your Honor, given the seriousness of this case, the reality is Mr. Florence cannot plead straight up as charged, otherwise the court would be bound to a life sentence. This is capital sexual battery. So even if it's a plea to the bench, there's going to be some sort of term to take that off the table.
Meaning the state has to agree.
Correct.
To reduce the charges.
That's correct.
And then you would enter a plea with reduced charges, but without a sentencing.
Correct. Okay. And I have been endeavoring to try to get a cap onto that. And as I said, if this is what Mr. Florence wants to do, then I would prefer to get this started, the ball started, in February as opposed to waiting until March.
Mr. Florence, I'll see you no later than March 13th. Thank you, sir.
Next.
Mr. Keach.
Judge, this is Matthew Palmer, and he's also represented by Mr. Kleins in a companion case.
Okay.
In my specific case, we have filed last week a motion to compel some outstanding discovery. I spoke with the state early last week upon filing the motion about some of those items. I know my office was trying to coordinate a hearing on that motion. I don't believe it's been set as of this morning. I didn't see a date come through. But if the court can schedule it today,
yes, sir.
Whereas time Tuesday afternoon, it's probably maybe a 15 at most 30 minutes to address some of those things. But we need those to be able to advance this case forward based on motion practice and potentially trial. There have been some rudimentary discussions as it relates to a resolution short of that. But I think the state needs to run some things up their chain of command potentially I know Mr. Klein's is also working to try to resolve his. So if he's going to be here anyway next Tuesday, maybe we could bring both cases back if the court has time to hear it.
Okay. I know that I've scheduled a lot of hearings for Tuesday afternoon. Do we want to do it on Thursday afternoon, on January 19th?
I'm actually out Thursday through I'm leaving the 18th through the 22nd.
Okay, if it's only going to be 30 minutes or less, then we can do it on January 17th at 1:30.
I mean, to me, it's a pretty basic motion to compel. So I would think it take 15 minutes, and also to give us an opportunity to resolve it if both cases are on the docket.
To the state?
Judge, I think we've pretty well taken care of what the motion to compel. I think the discussions that Mr. Keach and I have had, because I called him as soon as I got the motion to compel. One of the things is an issue. We had sent over some discovery, and the file, I believe, was corrupted, but it was also apparently corrupted within our office as well. So that's why we're trying to get a new copy of it. So we're trying to work on this, and I think some of the issues that really would be drawing out the hearing would be regarding the search warrant. But I think we've come to a resolution regarding the search warrant, and that information should have been sent to him. I think my sister was working on it today. You know, she was out with COVID all last week, so I know she was playing a lot of catch up, but her and I were in touch about it today of getting the details.
January 17th at 1:30?
That's fine, Judge.
Okay. So the motion to compel is scheduled then, and then also plea continue on the case.
On Mr. Keach's case.
On Mr. Keach's case, correct.
I have Mr. Palmer for plea or trial in 22 CF 1583. I am trying to get in touch with REAP. I emailed them early in December, and we exchanged some emails, and then I haven't heard anything. So, Matthew, I'm gonna make a phone call, at least one, to the actual program, see if I can talk to somebody, and then I'm gonna come up to the jail later this week and talk to you.
So what is that? What's that case number that's plea or trial?
That's 22 CF 1583.
Okay, 1583. And we'll schedule that also for 1:30, okay?
Okay. Thank you, Your Honor.
Thank you, sir. I'll see you next week on Tuesday.
And Your Honor, if I may, for the record, on the plea or trial case 22 CF 1583, state has made a downward departure offer, and that will expire.
Okay. So, Mr. Palmer, that means the state's offered, they're going to withdraw that next week. So talk to Mr. Kleins between now and then. You figure out whether you think it's in your best interest to accept that plea or not, but know that the state intends to withdraw that offer next week, okay?
Yes, sir.
Thank you, sir.
Judge, may I interject real quick on that?
Mr. Keach?
That main part, we're having two separate offers for one defendant. You know, he's looking at DOC in one case, but the state's turning around and offering him something different in another case, and it's just making it really problematic to try to bring this in for a landing. And I don't know if perhaps that office could, if we can try to paginate it or get all on the same page to help this defendant out, to try to resolve everything on the 17th. Because I think we could probably get something done if we can get a consistent offer that wraps up everything globally, but we haven't been able to do that yet. So, but hopefully if we're all coming back on the 17th, we can do such.
Thank you, Mr. Keach. I understand I can't make the state make an offer, but I understand your concern. Okay, thank you, sir. Thanks, Mr. Palmer.
You sent a video out. Next, close down.
Yes, sir. What's your name?
Robert Stansberry, sir.
Thank you, sir, Mr. Stansberry.
This is Mr. Stansberry, Judge. He's my client. We have deposition scheduled for this Friday, Mr. Stansberry. So I'd like to come back on docket day. I know we're going to be busy on the 17th. But having the depositions on this Friday, I'd like to see if we can gain ground to try to resolve the matter before next week.
Yes, sir. Mr. Sainsbury, I'll see you next week on Tuesday.
Next week, thank you, Your Honor.
Thank you, sir. Hello, Mr. Peoples. Mr.
Yeah,
Klein,
this is,
yes, sir.
this is Patrick Peoples. We do have a resolution to resolve this.
I have a written plea agreement that Mr. Peoples has signed, however, there's some things that aren't on it that I don't know if the court wants to take the written plea agreement in addition to all the other announced, or if the court just wants to do it. It's gonna be to probation.
Okay.
So I don't know if the court wants to just take an oral plea, or.
That's fine.
Okay. So Patrick, when we met last week, I forgot to tell you that one of the terms from the state is they're gonna drop one of these counts. They're gonna null pros one of the two counts, and the other count is gonna be pled to an attempted sexual battery, okay? The terms of the agreement, Your Honor, are that Mr. Peoples would be placed on 10 years of sex offender probation. That's going to run concurrent to any other term of supervision. The situation with Mr. Peoples is he was transferred back to the county jail after spending about 15 years in the Department of Corrections for something that happened here and in Bay County about 2003. And I don't know why this Okaloosa case was not handled at the same time that the Bay County case was. I don't know the terms of what he's on probation for with Bay County, but this 10 years will run concurrent to any other term of supervision. It will not be coterminous. It just happens to be concurrent. Mr. Peoples will be designated as a sexual predator. He will have to wear a GPS monitor at $1 a day. We did go over the special terms and conditions of sex offender probation. Those specifically, I'll turn it over to Ms. Berrickman to fill in the court on what those would be.
Certainly. It'll be a plea to count 1, which is an attempt. Madam Clerk, that is 777.04 subsection 1. That's the lesser included. And count 2 will be dismissed. 10 years of sex offender probation concurrent, not coterminous with any other case. Predator designation and the statutory requirements for that predator status. No contact with the victims in either count. No contact with minors and GPS. And as Mr. Klein said, part of the reason the state is doing this, it is an 05 offense for a cold case or an older case that actually the offense date is from the 1990s. And we were really only able to make contact with one of the victims, which is why 1 count is being dismissed.
Okay.
It is a downward departure based on a negotiated plea.
Mr. Klein, the written plea agreement that you have, does it have the terms of sexual offender probation in that?
It's not written on the face of it, but I have, when I was going over this with Mr. Peoples, I did circle the B, so we did go over the terms of that.
And did Mr. Peoples sign that?
He signed, well, he didn't sign he didn't initial or anything next to this, but he did sign the written plea.
Then I will take that.
Okay.
Thank you.
Do you want Ms. Berrickman to sign this?
It doesn't matter.
Okay.
I just want something that says that he understands what those terms are.
Understood. And when I was getting the case ready today, this is not the best plea.
Please. Mr. Peoples, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. Mr. Peoples, you can put your hand down. Did you read this plea agreement?
Yes, sir, I did.
Do you understand it?
Yes, sir, I did.
Did you discuss it with your attorney?
Yes, I did.
Did he answer all of your questions?
Yes, I did.
Are you satisfied with his representation?
Yes, sir, I am.
Did you sign the plea agreement?
Yes, sir.
Do you understand that if I accept your plea that you're waiving your right to a trial by jury?
Yes, sir.
Do you believe it's in your best interest to enter the plea?
I believe so. I'm really not sure.
Well, if you don't think it's in your best interest, then, the court's not going to accept your plea, and you need to talk more with Mr. Kleins. Okay, do you want to wait and have some more time to talk to him, and I'll see you on Tuesday, a week from tomorrow?
Yes, sir.
Okay. So we'll set it for plea continue, and I'll see you a week from tomorrow. Okay?
Yes, sir.
Read through the plea agreement, make sure that you understand all the sexual offender things, the designations, the GPS, everything. If you have any questions, ask Mr. Kleins. If you want to accept it next Tuesday, I'm going to ask you the same questions, okay? Thank you,
Yes,
sir.
Thank you. Next.
You're Mr. Palmer?
No, Mr. Murray.
Mr. Murray, good. Thanks, Mr. Murray.
We already took care of Mr. Palmer.
Thank you. Mr. Murray?
Okay. That's not Palmer either. Murray, come here. I don't know what Palmer is right now.
Hello, Mr. Murray.
How you doing today, sir?
I'm doing well, thank you, sir. Yes, sir, the PD, who represents Mr. Murray?
Yes, sir. I was seeking dismissal. I need a statute.
Okay, hold on one second. I think you have the public defender represent you, correct? It's Bradley James Murray?
Yes, I need a de novo review. I've been here 60 days. This officer acted in bad faith and wrote in.
Okay, hold on. I'm intentionally being rude because I don't want you to say anything that may hurt your case. Everything's being recorded in the states here. Trying to figure out if you've got an attorney. Both of them are digging at their desk to figure out who represents you. So Mr. Kleins is coming to the lectern.
Yeah, it looks like we've been appointed to represent him. I don't know why I don't have a file. I would like to leave Mr. Murray on for plea or continue next week, and I'll go to the jail and talk to him this week.
Okay. Is there an offer to Mr. Murray that Mr. Klein should know about?
Judge, he's currently charged with 2 counts of failure to register. He also has a hold for failure to register out of Pinellas County and possession of cocaine out of Pinellas County. State's offer would be to plea to 1 count of failure to register in exchange for dismissal of the other. Guidelines would be 62.175 months on 1 count of failure to register.
In the Department of Corrections?
That's correct.
Okay. So Mr. Murray, I'll see you next week on Tuesday. Mr. Kleins will come up and talk to you.
Yeah, okay.
Thank you, sir.
Yes, sir.
Mr. McLeod?
McLeod, yes, sir.
McLeod, thank you.
This is Mr. McLeod. We filed a motion of withdrawal last week. I believe the court's already signed an order. I can kind of fill the court in. We did have before we filed a motion of withdrawal, we were having Mr. McLeod evaluated for competency. I would expect Dr. McDonald's report, if we didn't receive it today, sometime this week. If the court wants to leave Mr. McLeod on for next Tuesday, so we can make sure we get that report and get RCC in here.
Yes, sir. Mr. McLeod, I'll see you next week on Tuesday, and Ms. Jaquith, your new attorney, will come see and talk to you. Okay? Thank you, sir.
Yes, sir. Thank you. Collins?
Your Honor, this is John Collins. We can leave Mr. Collins set plea or trial.
Okay. Is there an offer to Mr. Collins that the state intends to withdraw if he doesn't accept it next week?
Yes, Your Honor. Just one moment.
Mr. Collins, the reason why I ask that is to make sure that you're up to speed and that when we come to next week, if you say you want to go to trial, you know that the state is withdrawing their offer, okay?
Yes, sir, I understand.
So here's the offer from the state.
State's offer would be to dismiss counts 6, 7, and 8 in exchange for a plea of 1 through 5, 8 years from Department of Corrections, followed by 8 years of sex offender probation. Guidelines with the dismissal of the 3 charges would be about 7.5 years, the maximum of 55.
Okay. So speak with your attorney, Mr. Kleins, before next Tuesday, and I'll see you then, okay?
Thank you, Judge Brown.
Thank you, sir. And I think we have the Maxes.
I'll say.
As far as the maxes, do you anticipate any plea agreements being entered into, or can probation lead?
I do not anticipate any plea agreement for Mr. Scott.
Mr. Noakes, any plea agreements with your client?
No, sir, it's just gonna be request for continuance.
Okay. Okay, so probation, if you want to leave, you sure can. Thank you.
Yeah, they crossed 107 off the gates, we refused, so yeah, miles.
Mr. Miles?
Sounds good.
Mr. Noakes, is this Mr. Miles?
Good, I believe this is Mr. Miles, and we're asking to continue it, and I'll be out this week to talk to Mr. Miles and figure out how we're going to proceed.
Okay, Mr. Miles, then I'll see you no later than March 13th. Mr. Noakes will come out and see you in the jail, okay?
Yes, sir.
Thank you, sir.
Yeah, have a good night.
You too. Thank you, probation.
I'm going to log out, I think that's all I got.
Thank you, Mr. Noakes.
Yeah.
Keep on the next. All right. What's wrong, Scott?
Judge, this is Mr. Kenshawn Scott before the court in 21 CF 2481. To start off with, Mr. Scott, I tried to see you last Thursday and Friday, but the state, or the jail wasn't able to accommodate seeing a max. But that puts us in a position that Mr. Scott is charged with 1 second-degree felony aggravated battery with a deadly weapon. We announced ready for trial last time we were at pretrial, and it was continued over defense objection. And at that hearing, the court heard that the state was intending to file additional charges against Mr. Scott. As of today, they haven't done that. We are in a position that I know that Mr. Scott wishes to remain ready for trial. We have received medical records. We have also received a witness information related to a Jennifer Gilbert, who is located at the Okaloosa County Jail. That does not change Mr. Scott's readiness for trial based on our last discussions.
Okay, thank you. State, are you ready for trial?
Judge, I have worked on filing those new charges. I'm not sure why it hasn't made it into the court file yet. It's going to be a burglary of a dwelling with a firearm, as well as another aggravated battery with a deadly weapon. So it's going to be a case that he's looking at a PBL.
Did the state indicate there was going to be a second aggravated battery with a deadly weapon?
Right.
Is Ms. Gilbert going to be the alleged victim in that?
Right.
Mr. Scott, did you hear that? Can you hear me? Can you hear me, Mr. Scott?
If you'll speak at the microphone. There you go.
Did you hear what the state said, Mr. Scott?
Oh, yes, sir.
Okay. I wanted to make sure because what we're talking about today is serious. Does that change your readiness to go forward with trial?
No, it doesn't. I want to go to trial.
Okay. That's what I anticipated you were going to say.
I got a question.
Yes, sir?
Since I didn't get to see you, I couldn't talk to you. Can y'all place me for another bond hearing due to developments in this case?
Well, if you're here in court and we're tracking towards a trial, you'll be standing next to me in court on the 17th, which is next Tuesday. Any request we would make of the court, I would have to file a motion for. So I mean, that's the lawyerly way to say, yeah, I can do that. But really the crux of the issue is whether or not we're ready for trial or not.
We're ready, but I want to put in for a bond hearing too, just in case y'all continue it off until March or anything like that. So I would want a bond hearing within this month or to next month.
I told Mr. Scott, I understand if we're standing in court on the 17th and it looks like the case is going anywhere other than a trial, I've got no problem filing a bond motion for you.
Okay. So, Mr. Scott, I'll see you next week on Tuesday. I'm scheduling it for trial. So I'll see you on the 17th, which is next Tuesday. We'll have a jury review a couple days later, and then we'll be looking at going to trial either January 23rd or February 6th. If the court grants a continuance, if the state moves for a continuance, then certainly Mr. McKinney can set a bond hearing before March 13th. But I will see you next Tuesday, okay?
Right. And Judge, I want to apologize about my outburst last month in court.
Don't even remember what that was, so you don't have to apologize. Thank you, sir.
Thank you. See, Mr. McKinney, can you come see me pretty soon?
I'm going to try to see you as quickly as I can. I tried to see you last week, but the jail didn't have staff to make it happen. I'm going to certainly try again.
Please and thank you. I really need to talk to you.
Yes, sir.
Jail, is there? Go ahead. Anyone else, Jail? Jail, are there any other inmates?
No, sir.
Great. Thanks, y'all. Thank you so much. Court is adjourned. Oh, wait, I'm sorry. Court's not adjourned because Madam Clerk's got many things left. Right. Yes, sir. So the jail's adjourned, but yes, ma'am. Madam Clerk, if you want to call it.
Tyler Alhide McKinney.
Okay, and represented by who?
He's pro se on, he has Mr. McKinney, Scott Klein on 3 of his cases, but it's pro se on 1 of them.
Mr.
So, Your Honor, I don't know where Mr. McKinney is. This is a situation, I believe, where the first time the court ever saw him, it was a fugitive from justice case from the state. I don't know if he's out of state. I sounded the law for him.
Okay, what does the state seek?
The state requests a capias, Your Honor.
Capias will be issued, and the first appearance judge will determine the bond.
Okay. I have Mitchell Antonio Smedley, who's pro se.
Pro se?
That's a fugitive from justice that, my understanding was on December 12th, that was disposed of as far as the whole amount of state.
So is there still a pending case for Mr. Smedley?
There shouldn't be, Judge.
Okay. Why don't we just continue it until March 13th? And if the state, if you'll just check and see what needs to be done on that case.
Okay. I have Gabriel Acevedo Marty.
We had filed a waiver for Mr. Acevedo Marty, Your Honor. Dr. McDonald's not had a chance to get that waiver. So we're waiting on the court to determine whether or not he's competent to proceed. So I'm going to ask for a one-cycle continuance.
Okay, it's continued 1 cycle.
Darby Boudreaux.
Ms. Boudreaux was not present today. I don't know where she is. She's usually really good. She shows up on Zoom. I would ask if the court would allow me to pass her to next Tuesday. I'll try to get in touch with her, see why she wasn't here.
What does the state wish to do?
No objection, Your Honor.
Okay. Please continue for next Tuesday.
Peter Angman III.
Your Honor, we had attempted to take the deposition of our last witness in December. She was not available for some reason, so I would ask the court to continue this. Mr. Ingman's been a pretty long constantly just giving me all this stuff. So.
Any objection?
Given the witness unavailability, no.
It's continued.
Eileen Green.
Judge, I saw that she was added back onto the docket on Friday. She lives in Baltimore with her daughter. This is I think 26 cases involving uttering forged instrument that's a failed PTI. I would ask for the ability to continue this until March 3rd. She has been in contact with me in my office, and if there's a way that we can reach an agreement in restitution, we may be able to fulfill the terms of the PTI originally. I just need to know who's dealing with this from the state attorney's office.
Okay, so it's continued until March 13th.
Yes, sir.
James Terrence Hyam.
Your Honor, I'll leave this to the court and how the court wants to proceed. Mr. Hyam is in the Department of Corrections right now, and release date later this year in August. We're trying to get some kind of a resolution here resolved before we went off to DOC. If the court wants to issue a case, I would just ask the court not to distribute any bonds of Mr. Hyam.
Yes, sir.
But I'll leave that to you.
If the court does issue a habeas, the first appearance judge will make a determination, but no bond